Good morning, good morning, good morning, amazing law nerd. It's Wednesday, it's January 14th, 2026. I still can't believe it. There is a lot to cover today in the Kouri Richins case. And if you're like, Emily, you sound different. Did you do something different? Yeah, I got sick again, apparently. It's real annoying. I don't know what to tell you. So if you're like, girl, yes, 100%. But we have to talk about Kouri Richins. Remember, we got thrown out. Well, we didn't get thrown out. The judge sealed the hearing that we all wanted to watch. We were like, 2 days of hearings. Let's ride, Your Honor. And then he was like, no for you. So today we're going to cover the minute order that is a little difficult to parse, but it vaguely lines out what happened in that closed door hearing. Now, some of the motions that they covered were not filed under seal. So we're going to cover the motions that weren't filed under seal in kind of a vague, well, not a vague way. We're going to do it in a targeted way. Why? Because I'm not so sure how long my voice is going to last today. And B, a lot of the law is the same on those. So we're going to cover the facts of what the thing is and then look kind of more cursory at what the law is, because with these motions in limine, a lot of it is, but Your Honor, they're relevant and they fall under this exception to hearsay, or they fall under this rule of evidence, and it's things we've covered quite a lot. So we're going to go through it that way. So with that, we are going to cover the Kouri Richins stuff. I actually have some Kouri Richins breaking news for y'all that we're going to cover. And I promised you yesterday that we would talk about Attorney Jackson's response and see, well, Attorney Jackson's response to almost former, pending former, soon to be former District Attorney Michael Morrissey. So we're going to cover just briefly that statement and see how close it was to my presumption of what the statement would be, and we can chat about it. Then that is going to be it for today. We are going to hope that the voice hangs in there, and then we will talk about other stuff we need to cover. There is other stuff on the docket. There are other trials going on that we might see how we can cover in a shorter fashion. There are hearings coming up in February, and a lot of you have asked, Emily, are you covering this case with Judge Ascarati, the Banfield case in Virginia? It is slated for 4 weeks, and we have some other things coming up in that span of time that we are just not going to be able to cover it gavel to gavel day by day. I will talk to Team Baker and figure out how we can bring you some of the highlights of that case. Remember, we tried to do that with the Cardi B case, and it went very badly for me, but that's a much shorter case. So it might be that I summarize some witnesses and we watch key witnesses and watch some of the defense witnesses and do it in a much more cursory fashion. I will figure it out. I am not going to be able to do it gavel to gavel because it's going to end literally right before the Kouri Richins case begins. And so we are focused on the Kouri Richins case. That is slated to begin. Of course, things can always change, but we're going to talk about it. So we also have a hearing for Murdaugh that I am very, very interested in. And once we do gavel to gavel coverage, it's really hard to, interrupt this regularly scheduled program to do other hearings. And we have a number of other hearings in early February that I really want to cover. So we will figure it out. Will it be gavel to gavel at this time? No, but we will figure it out. And then for those of you asking about the Banfield case, we'll talk about it during Q&A. We'll chat about it during Q&A because I want to make sure that I get through what we need to talk about today without my energy levels and my voice expiring on me before we get to the main topics, because that would be the biggest wah of all time. It's and we chatted and now we're out. But I was chatting with Judge Abby. Judge Abby is also under the weather. She's like, I was trying to read through the jury instructions, and you know how much jury instructions the judges read. I'm like, how did that go? She's like, it was really tough. I'm like, yeah, talking when you are under the weather is not easy when you talk a ton. And so we were kind of joking about how it's just that time of year where everybody's it just is. It just is. So we have today for you just coming in. Hi, hello, good morning. Good to see you, Law Nerds. It's always good to be here with you, even when I'm slightly under the weather. Cue the people who skip the entire intro and then are in the comments later being like, you don't sound right. Correct. We have some breaking news in the Kouri Richins case. We are going to go through the judge's vague posting about the hearing that we all got excluded from so rudely, like the no, you can't sit with us. So rude. And we are going to cover Attorney Jackson's response to whatever the hell that statement was from soon-to-be former District Attorney of Norfolk County, Michael Morrissey. That's the plan on the docket today, isn't it? All right. Ready? Ready? I think so. Let's roll the intro and let's get to getting. Law Nerds, good to see you.
Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the Law Nerds in the chat. They're here for the facts, not and let's get to court.
I mean, we're here for the facts, not for the nonsense. I thought I had grabbed this statement. I did a very, very bad job of doing that. So let me grab it one more time as we get rolling today. Because remember, yesterday, the District Attorney of Norfolk County, Michael Morrissey, the news was reporting that he officially announced that he is not running for re-election. Now, this is somewhat anticlimactic to me because honestly, I just assumed that he had already said that because, girl, we knew you weren't going to seek re-election. And there are so many that have thrown their hat into the race. If you have not followed a DA race, especially if you live in Norfolk County, oftentimes they will hold like candidate forums and meet the candidates. This might be the time to get out into the community and ask questions of the candidates running for DA. Ask them about what they thought about these cases. Ask them how they would handle things differently. Ask them how they would charge these cases or what they would have done. Would you have sought retrial in the Karen Reed case? Go ask them questions if you are in Norfolk. Now, the rest of us would love to know the answers too. We are not the voters there. This is not our elected officials, but you have the right to do that. DA candidates often hold forums, and a lot of times they will chat with you. If you come up and are like, hey, give me a question, ask me a question, they will engage with you. So DA candidates can feel more approachable than other elections and more accessible. So go on out there and let us know if you engage with that. Find the candidate that you like. Look, I'm excited that Morrissey's not running for re-election. I think that the people of Norfolk deserve some answers. And I imagine that you want a lot of answers and you deserve them, especially regarding the kind of money that Morrissey spent on the second prosecution of Karen Reed. You deserve answers. You can go ask for them. And I'm sure the candidates will be somewhat candid with you because I imagine all of them are just like, yeah, screw that guy. And his statement, Morrissey's statement of like, I'm so incredibly proud about what is this and that. Oh, okay. Okay, sir, you keep telling yourself that. There are times I wish, Law Nerds, let me know if it's you. There are times I wish I could live in the delusion that we see from some of the individuals that we cover in these cases. Like, how do you say that with a straight face? Like, how are you just out here saying that and being like, cool with it? Like, come on. I don't know, but they are. So, of course, yesterday while we were streaming attorney, and I say of course because we know that Attorney Alan Jackson has thoughts. We know that we are going to see Attorney Alan Jackson in the media. This is not a man who was like, oh, call media relations. This is a man that was like, I've got you. Let me tell you what. So I'm not surprised that we heard from Attorney Alan Jackson. And hey, I love it. If you want to talk to us so we know what's going on, tell us what's up. So let's take a look real quick at what Attorney Jackson had to say following Morrissey's ill-advised statement. This is it. That Mateo guy in the chat said, Alan Jackson's like, I am media relations. 100%. Print that. I am media relations. Print it. I'm in charge now, FASBA. All right, let's take a look at the statement given to, let's take a look at my desktop, shall we? Apparently, every day it's going to be just a new thing to test how dedicated I am to live streaming, because yesterday it was our audio input. Today it's our video input. But you know what? Overall, so much better than what it was before. So I'm thrilled. Let's take a look at the statement given to Ted Daniel. I'm sure others have this statement as well. This is the first place I saw it. So there we go. Also, when Ted Daniel says he has a direct quote from somebody, I believe that he probably got that sent directly to him, right? Yeah. Mm-hmm. Karen Reed's attorney, Alan Jackson, just released this statement to me about Norfolk County DA Michael Morrissey's decision not to seek another term in office. What did I say yesterday? What I said yesterday was that Jackson's statement would be somewhere along the line of, good, he shouldn't, fuck that guy, print that. That was my summary of what I thought the statement would be. That was the translation into cursey words of the statement. So I also put more emphasis on it. I'm sure it's timestamped if you want to go watch it from yesterday's stream. But for those of you asking, who is Ted Daniel? He is a local reporter in Massachusetts. When I'm covering cases, I generally look, and I bring you the Bird app so you don't have to be on it yourself. I generally look for who is media local to the area covering a case and try to follow them specifically. I find that following local media to be helpful and more in-depth. So the statement from attorney Alan Jackson, quote, Michael Morrissey didn't so much step aside as the ground gave way beneath him. I mean, he's not seeking re-election, but yes, I feel like he's been swallowed up into a chasm or a schism, depending on, no, Emily, that's a Tool song, leave it be. It does feel like the earth swallowed Morrissey into it, and he's still just like, everything's fine, this is fine. Michael Morrissey is like the dog in the burning house meme, like, this is fine. He is the personification of dumpster fire at this point. Michael Morrissey didn't so much step aside as the ground gave way beneath him. His decision to not seek re-election comes amid the dismantling of nearly the entire Norfolk County Detective Unit. Facts. And the cloud of corruption that was finally brought to light during 2 failed and unjust prosecutions of Karen Reed became impossible to ignore, and Michael Morrissey knew it. I mean, yeah. Morrissey stated, again, the singer would like to be left out of it, but Mr. Morrissey stated that he is, quote, unquote, extremely proud. It's a choice, isn't it? Extremely proud of the office during his tenure. That speaks volumes about why public confidence in his office has collapsed and why his departure was not just necessary, but inevitable. So inevitable, in fact, that I thought that it had already happened. Public trust in the justice system is eroded when political cronyism is rewarded over fairness, when accountability is resisted, and when devastating errors are defended instead of confronted. Pride under those circumstances is not a virtue, it is a warning sign. Yeah, hubris will be punished when necessary, and Morrissey is going to have to live with the taint, if you will, of not just the Karen Reed prosecution, but also the Birchmore prosecution. And in the Karen Reed prosecution, while absolutely devastating to Karen Reed, the families of John O'Keefe, the fact that John O'Keefe never received a proper investigation after serving as a law enforcement officer and the community that it ripped apart, the Birchmore case is one of the most horrific cover-ups that I think I have ever seen. And it's different than the Reed case in the way it went down, but it's just horrific. And the fact that there's two of them so connected in time is chilling. And it also makes me question what we don't know. Like, if those are the two that we know about, what do we not know about? And that's concerning's not the right word. Frustrating is also not the right word. I need stronger words that I can say on YouTube. Horrific? We'll leave it with that. It goes on to say, Karen Reed and her team are honored to have played a role in ushering in a new era, an era of truth, accountability, and independence for Norfolk County. Okay, so chat, let me know, can this statement be fairly summarized as, it's about time, fuck that guy, print that? More eloquently stated, much more eloquently stated, but I appreciate that Alan Jackson took the time to say this was always going to happen. Morrissey essentially should be ashamed of himself. He should be embarrassed by what has happened to his office. And when the things came out about Norfolk detectives, MSP, Norfolk detectives, when that started coming out, what Michael Morrissey should have done was said, we need a top to bottom investigation and we need to take out everyone that is in this unit and bring in fresh eyes. He should have been outraged. He should have been outraged. And instead he was like, hey, Brennan, want to come prosecute a case? I got money. I got like an open checkbook. It's the taxpayers' money. Don't worry about it, man. I got you. Hundreds of thousands of dollars. Cool. I got you. Come on in. Go find somebody who will launch an SUV into space for us with some blue paint. No, I don't care how much it costs. It's good. Yeah, no, don't worry about it. Yeah, it's fine. It's cool. Let's go. Instead, he just doubled down, which is not his job. So this is why I strongly believe that people who are elected as district attorneys should have worked within prosecution and even defense, but should have worked within prosecution to have ingrained the ethical obligations of a prosecutor and to take that seriously, even if it seems a little too maybe altruistic and maybe too optimistic. But if you don't place that ethical obligation above literally everything else, you should not be in a position of control in a district attorney's office. You wield too much power and you shouldn't be there. Honestly, I would love to see, if Emily ruled the world, what would Emily love to see? I would love to see the district attorneys within an office choose who the head of their office is. However, I say that coming from a very large and diverse prosecutor's office where there would be people who would be amazing to lead, who wouldn't want to, who I think should probably be in charge. But it's also very difficult to take line prosecutors who do the job ethically and fantastically and turn them into political figureheads, which is essentially what a DA has to do, and then have them go like wrangle for funding for the office and stuff. So it is a hybrid position that is difficult, and it is a position that should be accountable to the public and also should understand the ethics of the job. But also, bye, Morrissey. We're not sad at all. It's going to be real interesting to see the continued fallout. I will say that it feels, well, everything feels heavy at the moment, but I am saddened that the Karen Reed case and the Birchmore case even happened the way that they did. They shouldn't have happened that way. If we could look at what an ideal investigation into those cases looked like, it would not be where we are now. But we can't change what happened. I have not figured out time travel to make things better yet. And, you know, when we look at the Reed case and the Birchmore case, where they are now, I am a bit optimistic that at least things are coming to light and changing. And even though it feels like it's not enough, even though it does not help John O'Keefe get a better investigation, it does not undo the murder of Sandra Birchmore, it doesn't change those things, it is coming to light. And that, I think, is helpful, because I think that we have gotten into a time where your digital footprint is so significant that you can't hide this kind of thing anymore. And I find that to be encouraging. It's going to be exhausting. It's frustrating, but I find it encouraging. So hopefully it will continue to change. And I remain optimistic in that, because I think there are still people who want to see it change. And we have seen better prosecutions in Norfolk. We have seen better investigations in Norfolk. It's not everyone. And it's not going to be everyone. But I'm hopeful that with a new DA, we will see more from the unraveling of the Norfolk DA's office. And I think that's appropriate. So I'm curious to see what else comes out from the Proctor cell phone dumps. Also, when you are looking at the Proctor cell phone dumps, I think we just get to keep our eye on the fact that everything Proctor touched is actually turning to complete shit. So we get to look at the fact that Proctor's phone has truly been like the tipping point for everyone else that he has touched. And so he really has infected those that worked with him, those that communicated with him. And keep in mind that when it feels overwhelming, if Proctor had figured out how to get rid of like his iCloud backups, we wouldn't know as much as we do now. So because we have Proctor's iCloud that he assured everyone was rehomed, we have the continued fallout for Sergeant Good. We'll see what happens there and more. So you don't always get to see karma in real time. But them getting into Proctor's phone and the prosecutor's office being like, we don't expect there to be much there. They've said that there's no backups. And then there are thousands and thousands of texts and photos and emails and videos and pictures and all the rest of it. Oops. So we're not done with this. This is going to be years long, and we'll keep talking about it. I mean, we're going to be here and we're going to keep being like, oh, interesting. Isn't that funny? Hard to be you, isn't it? Tara, I'm going to grab this question real quick, and then we're going to move on to talking about Kouri Richins, an investigation that has gone a completely different direction than all of these prosecutions. So Tara asks, could Morrissey face criminal charges? Not for the things he did while in office. He has a pretty fulsome immunity over the things he did in office. If there were things that he did out of office, then perhaps, but it would have to be things that happened outside of his official duties. And we can talk about prosecutorial immunity later. But for making the decision to, like, I don't know, I don't know what would be criminal. I would need more facts to even give a hypothetical, but for things that he did in the course of his work, generally no. Could Proctor be charged with perjury? He told his attorney, and his attorney passed on to the DA, we don't expect you to find anything. That wasn't a sworn and official statement. It was an expectation, and then everyone was surprised. I think Proctor was surprised. I don't think Proctor lied when he said, I don't think there's anything there. I think he was just incompetent. I don't think he was being untruthful when he told his attorney, no, you're not going to find anything. But doesn't that track? So yep. Leanna, Lenya, I think I said that wrong the first time. I covered the Birchmore case briefly. It is a federal case. It is really difficult. It is a very, very sad case. And I covered the facts of it when the arrest was made, but it is a federal case. We're not going to see it go to trial. We're not going to see much coming out about that case. So I've covered it briefly, but it's not a case we're going to cover for trial because we won't see it. Let's see. I'm going to save a couple other of your comments before we move on to the Kouri Richins case. My brain just paused. So let's see. Yeah, it is. The Birchmore case is really, really tough, but I covered it on a podcast. I don't know if there are more. I'm sure there's more. I'm sure there are places that are covering it more. Because of the way I choose to cover things, I covered the Birchmore case without getting into every single detail that is known so that you can engage with the coverage and learn about the case and then choose to find more detailed coverage if you want. I find that coverage can be maybe too much information for some because it touches on so many things that are difficult. And so I did not cover every single detail. I covered enough that you're like, oh, I don't want to touch that any further, or, oh, I'm interested to learn more. I can. Again, I try to cover things like the Ruby Franke case with Ruby Franke and Jodi Hildebrand. I tried to cover it so you could all engage with the coverage, know what's going on in the case without knowing every detail of harm that was done to the children, knowing harm was done and stopping there without knowing every single minute detail is how I choose to cover things when we are looking at them at a top level. Like, these are the facts you need to know. This is where I've sanitized some of those facts because it's really easy to find all of the details. It's much harder to find coverage, I think, that tells me what's happening and tells me what the law is without trying to hyper sensationalize details that are already horrific and sad. So that's how I approach things when I cover things, particularly when we are dealing with harm to kids who are victims, and then things that are particularly difficult. So I tend to choose to sanitize them, not for the platform, but so that you can find coverage and then make the choice to decide how much you want to engage with a particular case. And that is always how I want to cover things. That is going to remain the way I cover things. And then if we go to trial, I can let you know what's going to come up at trial and how much is going to come up at trial, so you can make the choice. I think you should have a choice. I think as someone who wants to be informed and as a law nerd, you want to know what's going on, but I feel that you should also have the choice of these details or this aspect of this case is where I'm going to nope out, and then I can pop back in later as it works for me, because you should have that choice, right? I think you should. You don't have to know every single thing to understand a case. And I think that the media takes those difficult things and then sensationalizes them. And I don't think that's helpful. I don't like it. Also, I don't think it's needed for understanding, and I don't think it helps defendants or victims. I mean, when you look at a case like the Karen Reed case, how many years till you get to an acquittal, and how much damage is already done before you get to an acquittal? There are some that will forever have an opinion of Karen Read without watching the trial from early on headlines. And there's not much that can be done about that. And there's not much that can be unwound. So keeping in mind that we'll know what we know when we know is fair. Yeah. So that's how we do it. This is how we do it. I think audiences should have choice. So weird. I know. All of you should have choice. We should be given choice. And a lot of coverage doesn't give us choice. And I hate that. So we do something different. And we try to. And then, if we get spicy about things, we'll get spicy about things that are grounded in fact. Like the Kouri Richins walk the dog letter. I am going to be spicy about that forever. And I'm going to tell you, I'm going to be spicy about it. There are things in that walk the dog letter that I don't like. I don't like them. I think it's bullshit. I think it's fuckery, and it pisses me off. But when we go into the Kouri Richins case, everyone who's new for that case, I'm going to remind them, hey, we know a lot about this case. I know a lot about this case. I am coming into this case with a ton of information. So I already have some opinions. It doesn't mean you have to agree with my opinions. We're going to watch it play out. But I will let everyone know where I'm coming into that case on because I have thoughts. All right. I know, you're right. Living This Mom Life says it was a novel. It wasn't a letter. It's a novel. It is the most detailed book that ever booked. That's 60-ish pages. Oh my God, Emily, don't wiggle your head. Your head hurts. Oh boy, today's going to be like that. All right. Are we ready to go to Utah? We've got breaking news. Are any of you in the chat new to the Kouri Richins case? Hold on, let me just put up a poll because I love that we have new law nerds all the time, and I want to make sure that we cover it. Let's see. A number of you have come in and have asked me about the Banfield case out of Virginia. I talked about it a little bit at the top of the show. We're going to find a way to cover it. I'm not going to be able to do gavel to gavel because the timing is just not going to work ahead of Kouri Richins, but I will find a way to bring you guys coverage of that case. I know a lot of you are interested. It's going to be modified coverage, though. It's not going to be gavel to gavel. It's not going to be every witness. Some of you are new to this case. A lot of you aren't. All right. Take vague notes. That joke will make sense in a minute. Let's fly to Utah, shall we? To Salt Lake we go. Which housewives will be on our flight? And will there be any TikToks that people will be fighting over? Who knows? Will it be a flight that we talk about or a flight that nobody knows about? Emily, are you still behind? Yeah, I'm still behind on Real Housewives of Salt Lake City. It's because I was watching Traitors and my family is still finishing up Stranger Things as a family. So, yeah. All right. Let's go. To Salt Lake we go. For those of you new to the coverage, let's just do a brief road so far and overview of what's going on in the Kouri Richins case. Utah versus Kouri Richins. She has been accused of the attempted murder and then subsequent murder of her husband, Eric Richins. They had multiple children together. Their young children are now with Eric Richins' family. She has been in custody since her arrest pending trial. She was not arrested for a little over a year on this case because and it took them quite some time, as we learned in pretrial motions, to get into Kouri Richins' cell phone. So in the time it took them to get into the cell phone, this case went without an arrest, though there were numerous conversations with her. The aggravated murder charge or the first-degree murder charge is from March 3rd, 2022. The attempted murder charge is from February 14th, 2022. Yes, Valentine's Day. There are also numerous fraud claims and false insurance claims that are going to trial alongside and with the attempted murder and aggravated murder charges. There is also a completely separate case involving forgery, mortgage fraud, and other fraud that will go after the murder case if it goes to trial. If she's convicted, it would not surprise me if they are able to resolve that. But There are underlying financial aspects of this case that will seem very Murdaugh-like as this case unfolds. Kouri Richins is alleged to have forged Eric Richins' name to take out a home equity line of credit on the home. Of note, that home was in his name only. It was his property prior to marriage. Then you have her taking out life insurance policies where the initials and signature of him were forged, among other things. There has been some information in the media about other life insurance policies. That's never been substantiated, and that I am treating as just rumor. There was a significant amount of debt. In the Walk the Dog letter that we'll talk about in a few minutes, Kouri Richins was talking about running $1 million business. However, when you are owing more than $1 million, that doesn't count as running $1 million business. She was servicing tens of thousands of dollars of debt a week. Well, supposed to be. And so with the numerous life insurance policies out on Eric Richins' life in connection with messages we see from her phones and others, it's alleged that Kouri Richins was attempting to procure narcotics from numerous individuals, eventually was able to get that from someone who agreed to work with police. CL, we will see that individual testify, talked about going to the Maverick and Draper and procuring narcotics from a third party who will also be testifying at trial, we believe. After February 14th, Kouri Richins reaches out and says, I'm going to need something stronger. She, in those conversations, was saying essentially, we need something for back pain. We need something for this. We need something for that, but was looking for propofol, fentanyl, and others. So after Eric Richins got incredibly sick on Valentine's Day, Kouri was asking for something stronger. There is also a notebook where Kouri Richins was like, Dear Diary. This is all exposition on my part. This is not in the notebook. This is me being rude. We're going to do it anyway. Dear Diary, the news says that if people are even around fentanyl, they die. And alas, my husband is still not dead. So I am going to need something stronger. So there's also a journal that law enforcement took that's the subject to some of these motions that we're going to talk about today. Kouri Richins asked for something stronger and at the same time is messaging her side piece, who in all the legal filings is referred to as a paramour, is messaging her side piece that they're going to be together soon, just like give me till Friday. Give you to Friday, you say? Interesting. So then Kouri Richins calls the police, says that she finds her husband unresponsive, says that she had fallen asleep in one of the kids' rooms. This story starts to fall apart even more so once they get into all of the devices. She's arrested in May of 2023 and has been in custody since. There's been a lot of pretrial litigation. She changed lawyers. There was the motion to change venue. That motion to change venue went up on appeal. And also, even though I feel like personally offended that he hates all media, I really like this judge. I really like Judge M. First of all, he has a voice that could read the phone book and people would pay for it on OF. Second of all, he is incredibly well-researched, well-versed in the law, and he runs his courtroom as a very tight ship, which I love. I just love it. He looks at the attorneys and are like, I need you to focus on this, this, and this. And then he just rules from the bench because he's prepared before his cases. I just adore Judge M. He is conscientious, considerate. He follows the law. He explains his rulings. I just love competence. I love it. We stand competence. So what we are covering today is the breaking news, the motions that we got brutally rebuffed from getting to watch, and the motions that we have on the record that we didn't get to. We're going to cover it a little bit. So are we ready? Are we ready to get into that? All right. So first things first with the Kouri Richins case is that, and some of you see it in the chat, this was on the docket this morning that the court approved, and I pulled it from the docket. I'm sure it's been announced elsewhere now. I should have said it at the top of the stream, so I was first, but I didn't. On the docket this morning was the judge's approval for streaming the trial. That was in the docket today when I pulled it before stream. So Court TV has been approved for pool, and the court approved live streaming. I didn't think this was going to happen. I didn't think this was going to happen at all. So the fact that we are here, just thank you, Your Honor. Thank you. Thank you so much. So the judge approved live streaming. It was docketed today. Court TV will be pool. Yay, Court TV. Yay that we have streaming. Yay that we're in mountain time. Let's be real. Yay that we're in mountain time. Also, it seems like a case that is going to be dark on Fridays. Yay. Yay. So in all of this, I suspected that the judge might change his mind once the jury was selected. And the judge's caveat to that has always been, you cannot show court staff. So Brittany, who we hear about, his court clerk, is one of the individuals that they're like, you can't show the court staff, which is going to be like the clerk and what have you. The bailiffs will occasionally end up on screen, I'm sure. But we are not going to see court staff. And he also put a note, any child witnesses. I do not anticipate that there will be any. I do not think that there will be any child witnesses. If there are any witnesses under 18, then they will not be shown. I am sure that someone will go pull the court records and will start to spin on the internet about the fact that, oh, the kids are going to testify. I do not expect that the kids are going to testify. However, if we get to impact statements, they may have impact statements from the children. Generally, those would be written and read into the record. We don't know. I am not assuming that we are going to have any witnesses under the age of 18. I think that is a standard caveat to all the cases that the judge does, because if you don't say it, you never know. So I do not think, so if you hear anyone saying, oh, the kids are going to testify, I do not think that that's true. I have not seen them indicated on the witness list. I have not seen anything to indicate that they would need to testify at all. However, if this is a case where there's a conviction and then it gets to impact statements, there may be an impact statement. I think the judge is leaving it open for that possibility. So do not let anyone spiral sideways because there's a caveat. The thing about making a court order is you need to include all of the information at the beginning. So all of the information at the beginning. I do not think we will see the kids testify in this case. They were asleep when this happened. They are incredibly young. Not helpful. So I don't think we will see that. So that is my caveat on that. Okay. So we have streaming for the Richins case. I didn't think that we would. I'm so glad that we do. I was worried about how it was going to work out. And I'm like, it's all going to work out. It's all going to work out. It's going to be fine. And here we are. So let's go to the 7-page, not 6-page, 7-page updated minute order from the hearing that we were excluded from. This minute order has the vaguer recitation of what happened at the hearing and what's going on. Shock Art Journal said, I'm confused. Who's Brittany? The court's clerk. And we hear the judge refer to Brittany a lot. Brittany sits next to the bench where the judge works, and we will hear him reference his clerk on the record. But when the court says do not show the court staff, he's really talking about like the civilian court staff that works next to him on the bench. And we know that once Court TV has this courtroom lined out, they did a really good job in these courtrooms, I think, for the Gwyneth Paltrow ski collision case. And I think the court could make similar orders like that. You focus on the person who's speaking. You can focus on the podium. You don't zoom in on any of the parties. There's room for the judge to craft an order to keep it from like counting the pores on the defendant's, nose or whatever. And Court TV does a good job of putting in this layout of courtroom, like putting a camera behind the witness podium to show the attorney's tables and the podium, and then one facing the witness stand. The thing that I like about being in court via camera is if you're just watching in court, you're seeing the back of everyone's head except for the judge, the witness stand, and the side profile of the jurors, and you're not getting microphone in court. So I appreciate when we have the view of the attorney tables where you can see them from the well of the court or from behind the witness stand, which is an advantage you can't get if you were sitting in court looking at the back of everybody's head. So I'm glad that it's streaming. I'm very excited. When I saw that this morning, I was like, he approved streaming. He ticked the box. I was so stoked. So when I grabbed that this morning, I was thrilled. I couldn't wait to share. So when does trial start? Well, opening statements should be February 23rd. So we will be starting this case February 23rd with opening statements. If they get a jury sooner than that, I don't know if the judge will bump the opening statements sooner. So we'll see. It's always a possibility that we're going to keep an eye on, but I don't know if the judge will do that and bump it forward if they get a jury faster. Remember, they have like 1,300 some odd, or no, it wasn't quite that many. They sent out like 1,300 questionnaires. They have like almost 1,000 questionnaires back or something. They're going to be able to pick a jury from those questionnaires pretty well because they can narrow down those questionnaires. And I think the judge is inclined to yeet everybody who's heard about this case. And look, when I was looking at the case in Virginia yesterday to try to figure out how we're going to cover it, and how I wanted to do that because it is a 4-week case and it's going to bump right into this, or right into the Richins case. I had heard about the case going on in Virginia right now. They're calling it the au pair murder case, but the Benefield case. I had heard about it. It was the same with the Walsh case. I had heard about the case, but once they got into opening statements, I'm like, oh, I didn't know all that. It's going to be the same for a lot of these individuals with Kouri Richins. Like, oh, I kind of heard it referenced, but I don't really know. That's how a lot of people hear about these cases unless they're really engaging in this case. So LJ Peach, I have not seen anything that indicates a delay. I grabbed the wrong one, but Northwest, I don't think it'll last 4 weeks, but that's what they told the court. And I don't think there will be a delay. I mean, we're going to be slightly delayed because we'll pause and talk, but we'll be able to cover it closer to real time, and it's mountain time. So I probably won't delay the morning as much. Otherwise it's going to get quite late for myself and for those on the East Coast. So I will try to balance it, but West Coast folks rejoice. I mean, West Coast folks rejoice that trial's not going to be starting at like 5, 6 a.m. your time. And international crew, when it's easier for you to catch things that are later in the day, this will run a bit later in the day because it will start a bit later in the day. So I'm very curious as to how the Richins case moves forward in trials. So let's look at what some of the evidence is going to be in the Richins case, because that's the bulk of what we're covering today before Emily tries to find more Dayquil. That's what we're doing, or something. So Emily, we're covering all of this from a minute order. Yep. Because there's no orders on the docket. Actually, let me pull up the docket real quick. Let me log in and pull up the docket because we actually might need it today. This docket, half of it's just like sealed. So it's just like private. It's private. Also, I appreciate the courts so much that have easy public access to court records, but this judge has been like, oh yeah, when in doubt, just seal it. So after this case, there's going to be a lot that comes forward that was sealed that is going to take time to go through. It's just going to take a while. let me pull this up just in case we need it before we get rolling. Yeah. All right. All of you in the replay crew are going to be like, why am I getting ads for cold medicine? Sorry. Because I said it. All right. This is from the hearing on January 8th. We weren't invited to. You are going to see some notes on this docket in different color. I made those notes as I started going through this because I needed the reference point because there is so much. This is a full day of hearing with a lunch break, and I needed that information as well. Also, I'm going to need to find another. That's the goal this year. I'm going to find another PDF viewer that I like better than this to make it easier. But alas, here we are. The charges that are going to trial on this case is aggravated murder, which is first degree premeditated murder. Attempted criminal homicide, which is attempted murder. That's the Valentine's Day. Meet 88. Emily's still bitter about being uninvited. 100%. I'm so triggered. I'm so salty about it. Also, at least half of these docket items that they cover were not filed under seal. So the court could have done half of the day, like, hey, we're covering docket this through this that were filed publicly, and then we'll seal it at lunch. This was not the least restrictive means. There was a less restrictive way to do this. They could have just sealed half of it. So, yeah, I'm still salty about it. I like this judge and I wanted to know. Counts 3, 4, and 5 are the fraudulent insurance claim and the forgery. So that is what is going to trial. The insurance claims we'll hear more about, but those refer to the victim's life insurance. Hearing, all parties appear in person. Today's hearing will be sealed. Counsel for the state, Mr. Brewmeister. Burmeister? Barrister. Which I think Brewmeister works better. Emily, sure, whatever. We're going with it. This is the newer addition to the in-court DA personnel. They were addressing the court regarding a warrant. That was not regarding the things that were on calendar for that day. There is a conversation regarding a warrant. Ms. Nestor addresses the court with no objection. The court issues the state to resubmit the warrant. So whatever the warrant they were doing, the court allowed them to do it. Those were kind of housekeeping items prior to getting into the motion for the day. Getting into the motion for the day. Counsel for the state, Mr. Bloodworth, requests that the court address the motion to determine the admissibility of docket 913. What is docket 913, Emily? Docket 913 deals with docket 214, the walk the dog letter. Somebody in the chat asked earlier if the court knew about our coverage of this case. Yes. We know that this court knows about the law nerds. My channel has been referenced by subscriber size. And, well, there's also this.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
Yeah, they know that we call it the walk the dog letter. Bloodworth is aware of the law nerds. Emily has a full rampant running conspiracy theory that the judge's wife and family are just like, can we stop thirsting over judge? It's like, but we're harmless. It's really, we love competence. I mean, and voice and beard and what have you, but we're just over here in our own little corner. We swear, we want to see this case go to trial. So docket 913, counsel for the defendant, Ms. Lewis, addresses the court regarding the motion. The court, for the reasons stated on the record, grants in part the state's motion to determine the admissibility of docket 913. Let's go take a look together at docket 913. We have not looked at this together yet, but we're going to look at what the prosecution was asking for in docket 913 because that was filed publicly and we have it. We are not going to do another dramatic rereading of the walk the dog letter. We do not have bandwidth today. We'll link it below. There's a playlist for this case. If you're like, what the hell is the walk the dog letter? Don't worry. We've covered it. We've covered it. This is docket number 913 that we're looking at now, relating to docket number 214. This is the state's motion to determine admissibility of the walk the dog letter. Argument. The walk the dog letter is authentic. The walk the dog letter was written by the defendant. The defendant has admitted that she wrote the letter. She called it not a letter, but she admitted it. The Sergeant Thomas located it inside the defendant's cell inside her LSAT study book. The walk the dog letter is non-hearsay. It's the statement of a party opponent. The walk the dog letter is relevant. And then they define relevance. Specifically, the prosecutor says the first 3 pages of the walk the dog letter are relevant because the defendant uses them to solicit false testimony, which reveals her consciousness of guilt. Prior to her arrest, the defendant consistently maintained to law enforcement, the Office of the Utah Medical Examiner, and a life insurance company that Eric Richins did not use illicit drugs other than the occasional THC gummy. As set forth in the opposition at docket 794, the first 3 pages of the walk the dog letter instructs the defendant's brother, Ronald, other Ron, instructs defendant's brother, Ronald, how to testify in support of her newfound and otherwise entirely unsupported theory that Eric Richins obtained fentanyl from Mexico. Why solicit false testimony to support a fabricated defense unless you know you are guilty? Renee asked, why do they call it the walk the dog letter? Renee, I've got you. Let me show you real quick. This is best used. This is best with a demonstrative. One second. Y'all, I don't know if Kouri Richins is planning to take the LSAT from custody. I mean, she can write a letter to Kim Kardashian about studying for the bar. I don't know. She seems to have taken quite a lot of courses in custody, and I have no shade for that. It will keep people busy. And I think that that's probably better. I think that's probably better for them. But the reason it's called the walk the dog letter is because this is what it looks like. The top of the letter says walk the dog. But take vague notes so you remember. Now, I have my own opinion on why she is using walk the dog. Other people have their own opinions, but I see the abbreviation WTD as what to do, not walk the dog. But that is purely, chat, purely.
That's my opinion!
It's purely my opinion. It's purely my opinion. Do we know that from this case? No. Do we know what Kouri Richins was thinking? No. But WTD, I think it's what to do. That's how I read it. So that is purely my speculation. Does she really mean walk the dog? No, she means get the story together. Get on the same page. Get together. This is what we're doing. Or it's the title of the book. That's true. That's just the title of the book. Right, because it's page 1. However, she says in her jail calls that this is from the middle of the book, so it's challenging. Because the book had a title, I forget. It was in that jail call that we covered. The book did have a title. The title was not riveting. And she is a published author, you guys. Remember, she did write or put her name on a children's book about grief. So there is that. That's the walk the dog letter. And that's why we call it the walk the dog letter, because it's written at the top. The Peace Love Carrie in the chat said, who did she write the letter to? It was written to her mother. So it was, Mom, tell brother to do these things. Tell brother to do this. The first 3 pages of the walk the dog letter are relevant because the defendant uses them to solicit false testimony, which reveals her consciousness of guilt. And I love that the prosecutor ends this with, if not guilty, why guilty shaped? If not guilty, why story? If not guilty, why do you need your brother to come up with this whole fabricated story about what he knew? Why do you need to do that? This is a consciousness of guilt argument. That, look, it's like Donna's letter. This is very much akin to Donna Adelson telling her bunkies, like, hey, I need you to talk about Catherine McBanawa. This is what I need you to say. Stupid fool. Come on, guys. Let's all get on the same page. All right? That's what this is. This is the Kouri Richins version of Donna Adelson's script. People think they're more charming than they are, is what it is. The prosecutor goes on to say, moreover, the first 3 pages are relevant because the defendant writes, quote, Eric asked if Carmen could get him some pain pills and fentanyl. This corroborates the defendant's admission that she asked Carmen Lauber for pain pills and Carmen's statement that the defendant asked her for fentanyl. Remember, what we have seen in all of the pretrial motions, the bond hearing, and the preliminary hearing is that the defendant was reaching out mostly on Facebook Messenger, but on defendant's phone, a lot of these things were deleted. They were deleted off the defendant's end, not the other end. And the defendant asked other individuals for pain pills, or I think she actually said that Michael Jackson shit, referencing propofol, to other people. We didn't even talk about the Googling of it all yet. That'll be that'll be for later. And we'll see what Googling comes in this trial. But it will come in for consciousness of guilt. When she is Emily, you're going to just say it now. Yes. When she's Googling things like luxury prisons for rich people, why are you Googling where you might go to prison if you don't think you're going to go to prison? Oh, chat, you're correct. My bad. Research for the book. Yeah. Research for the book. That's right. That's right. Research for the book. What are luxury prisons like for rich people? No. You've got to be rich enough so they won't even think of prosecuting you. That's the goal. That's the goal, Kouri. You're not there. Most of us aren't. Continuing, the prosecution says in those first 3 pages, the defendant writes that Eric asked if Carmen could get him some pain pills, corroborates defendant's admission, corroborates Carmen's statements, the defendant's consciousness of guilt, as well as corroboration that the defendant purchased fentanyl from Carmen Lauber, tend to make it more probable that the defendant poisoned Eric Richins with fentanyl. Yeah. She's asking everyone for fentanyl, and he dies from a fentanyl overdose with a metric fuck ton of fentanyl in his system. And unlike other overdoses, it's not near him anywhere. There is none found in the house. Why is there no fentanyl found in the house if he overdosed accidentally from fentanyl? Also, if he was taking that much fentanyl, where is the cup that he was drinking from? She said they were celebrating and drinking Moscow Mules in bed, which, sure. But wouldn't you just put it on the nightstand if you were drinking something in bed? But it was completely cleaned up and gone. So also, there are so many issues. I'm not going to argue them all. We're going to wait for trial. But in overdoses, generally you see the thing the person overdosed on near them. Wolf Chiara, she said she made herself a lemon drop and made him a Moscow Mule. So there still has been some potato about who made what, but she said she made herself a lemon drop. Look, no shade to a lemon drop. I love a good lemon drop. There was a restaurant that is since closed, which makes me very sad, that made a lavender lemon drop. Oh my God, it was just so good. Just so good. But the mug was gone from the drinks that Kouri said that she made for her and Eric to celebrate the closing on a property that further put her in debt. So, but as consciousness of guilt, this letter was written and recovered from custody well before we ever get into somebody saying, I don't know if what I sold to Carmen was fentanyl or not fentanyl. I don't know. There have been some changed statements from the dealer that, gave it to the middleman that gave it to Kouri. And if Kouri is the one writing, hey, I asked her for fentanyl, and then Carmen testifies, yeah, I was asked for fentanyl, and then I asked a contact, and then the contact said, I got you, and then I went and picked up pills, and then I gave them back to Kouri. Even if the contact says I wasn't selling fentanyl, I was selling street, oxy. Well, what was asked for was fentanyl. You sold something to Carmen. Carmen gave it to Kouri, and Eric ended up dying of a fentanyl overdose. So even if you say you think it's this or that, okay, sure. Also, I think with the state of the crackdowns on fentanyl, I imagine most wouldn't want to get on the stand and say, yes, I was selling that, even if they have a deal. I can imagine there would be some discomfort. Fine. But her writing it in the letter is her telling, well, I didn't ask for the fentanyl. Eric was asking for it. So it goes along the lines of the accidental overdose story that Kouri Richins told to law enforcement all along. She didn't mention her paramour in any of those conversations. I mean, it comes up in the walk the dog letter, it seems. So what does the prosecution want to admit with the walk the dog letter? The first 3 pages. They're not trying to admit the shit that Kouri Richins said about her sister-in-law. They're not trying to admit that she's trying to smuggle Crest white strips into the jail. They're not trying to admit things that just make Kouri Richins seem deeply unlikable. They are narrowing this letter down to the things where Kouri is saying, I need you to say. Also saying Sky, her former attorney, Sky needs to make this connection. Tell Sky at the meeting. So they're not seeking to admit the whole letter. Emily, how long is that letter? Hold on. 6 or 7 pages long? It's 6. Chat, it's 6 pages. So they're seeking to admit half the letter. They're not seeking to admit the other half of the letter. And the other half of the letter is Sky's having my girls do an interview on Good Morning America. She means her friends, not the kids. Sister-in-laws are jealous of me. Mortgages on houses and things like that. The mortgages on houses will come up in the second trial if it goes to trial. That'll come up in the mortgage fraud stuff, possibly. But the first 3 pages end with, take vague notes of all of this so you remember before you walk the dog. Tell the story. Get it done before you walk the dog. Not an actual dog. So half of the letter with all the stories. Tell them to say this, tell them to say that. The motion goes on to talk about the probative value is not substantially outweighed by unfair prejudice. The defendant said it. They go on with the case law on that. We're going to zoom through the case law. I was just looking for the specifics. And then let's get to the argument from the prosecution on this, saying the first 3 pages of the walk the dog letter are probative for the same reasons they are relevant. Nothing in the first 3 pages is unfairly prejudicial. Soliciting false testimony does not appeal to the jury's sympathy, arouse a sense of horror, or provoke its instinct to punish. Her fucking with her sister-in-laws kind of does. But this part is literally, go tell this story. The first 3 pages do not describe or delight in Eric Richins' death. They say, indeed, it's difficult to get most people to even care about witness tampering. I mean, fair. It goes on to say that nobody forced or coerced the defendant to write the walk the dog letter. The defendant holds a master's degree. Really? In what? I was unaware. The defendant holds a master's degree. The defendant was not being persuaded. She wrote the letter risking the likelihood that sheriff's deputies would find it and recognize it for what it is. Any prejudice is entirely fair and well earned. Oh, Bloodworth. Write it, regret it is where Bloodworth is going. Write it, regret it. The 403 balancing test, of course, does not consider level scales. Any unfair prejudice must substantially outweigh the probative value. Here, the first 3 pages of the Walk the Dog letter is highly probative because it bears directly on defendant's agency in Eric Richins' death. It's difficult to imagine how any unfair prejudice from the first 3 pages could substantially outweigh its probative value. Does the defendant's concocted story tend to prove that she was involved in Eric Richins' death? Yes? Okay, well, it's going to be prejudicial. It's a trial. The prosecution has to move the ball from presumption of innocence to guilty beyond a reasonable doubt. It's going to be prejudicial, but it also has to be helpful. Is this letter helpful? Yes, I think it's helpful. They are also saying it's not offered to show bad character. It's not being offered to show like, oh, she just sucks. It's being offered to show that she is trying to concoct a story to save her own ass. That is me summarizing. That's not the writing of Mr. Bloodworth. He's more eloquent than that. So it goes on to argue consciousness of guilt and the law in consciousness of guilt and how it plays in the balancing. The court should find the first 3 pages are admissible. So the court granted this in part. Do we know what part the court granted it in? No, because it doesn't say. It just says, for the reasons stated on the record, the court grants in part the state's motion to determine admissibility of 913. If I were to speculate as to what the court might have done in this circumstance regarding the Walk the Dog letter, it's that there needs to be proper foundation laid. The court can't just say, oh, it's admissible. Like you have to lay the proper foundation. They have to prove first before it can come in that it was written by Kouri Richins and how we know it's written by Kouri Richins, etc. So the court had done that a lot in the first day of the hearing, saying, yes, if you meet, the other foundational elements for admissibility, then it is going to be admitted. The defense, of course, was fighting to keep this out. The defense was arguing not just hearsay, but that it wasn't probative. The defense had also at some point argued attorney-client privilege, among other things. The defense had also argued years ago in this case at this point that the search on the defendant's cell was improper and that they couldn't prove that the letter was shown to anyone so that the letter couldn't be admitted. It doesn't matter if the letter was shown to anyone. It matters that she wrote it. It doesn't matter if she was able to complete telling her brother the Walk the Dog story through her mother. It matters that she tried to. It's also going to matter if the defense tries to bring in the mother or the brother to testify. It's going to matter a lot. So I think the Walk the Dog letter will come in after foundation is laid. And I think we'll hear about it some in opening. I would be surprised if we don't. Like the defendant's going to try to say this is a accidental overdose. It's not. They move on then to docket 917. Counsel for Bloodworth requests that the court address the motion to determine the admissibility of docket 917. Docket 917 is the orange notebook. The orange notebook came up during motions to suppress, and the court had not suppressed the orange notebook. There were some other foundational issues with regard to the orange notebook. Emily, what's in the orange notebook? We're going to have to go to docket number 917, which is what we're going to do next. Counsel for the defendant, Ms. Nestor, addressed to the court regarding the motion. Ms. Nestor further addresses the court regarding a continuous objection. So Ms. Nestor is like, we object to the orange notebook and we keep objecting. Bloodworth argues the court addresses the parties regarding laying foundation at trial. Counsel for the state, Bloodworth addresses the court. Nestor addresses the court. Bloodworth requests that the court address the motion to pre-admit notes. And then they move on from there where the parties go back and forth. They talk about laying foundation. They talk about witnesses. They talk about making a showing. The court rules at trial, the state needs to make a showing. So I think that what the court is saying on the orange notebook is that you must lay the proper foundation at trial. I'm not going to tell you the foundation's been laid, but you need to show that the notebook that was taken out of the house belongs to Kouri Richins, was written by Kouri Richins, and when it was written by Kouri Richins. You need to be able to show those things. Emily, what's in the orange notebook? Well, law nerds, I'm so glad you asked. Let's go grab, what was this, 917? Let's go grab docket 917 real quick. We have not looked at this docket number together either. Emily, why didn't we look at these? Well, most of them were filed while we were in the middle of covering other trials. And so we are getting to it closer in time to this trial because, well, that's when we have time to. Emily, I know you're thinking to yourself, but if these were filed publicly, why couldn't these motions have been heard on the record? I agree with you. I think the court could have done at least half of this hearing publicly. But he didn't, so it's fine. Docket 917. State's motion to determine the admissibility of the orange notebook. This is the one I refer to as like, Dear Diary. Vanilla Bean said, isn't laying foundation standard anyway? Yes, and oftentimes you will have the parties agree to foundation, and the defense is going to say, we have an ongoing objection and we're not going to agree to foundation. Like, foundation has to be laid here. So, yes, and. The state respectfully moves the court to determine the admissibility for trial of the first 5 pages of the orange notebook, docket 914, non-public, Bates 1075 to 1079. So we do not have these items. These were filed under seal. We don't know what's in them, but we're going to find out a little bit more about what they are. Statement of relevant facts. Detectives seized an orange notebook from the defendant's place of residence on the day that the state charged her for aggravated murder. Sorry, we need some. We are just not all the way healthy today. And my whole face is dry. All the things. The first 5 pages of the orange notebook contain defendant's handwritten journal detailing the events of March 3rd and 4th, the night of Eric Richins' death. What? What now? First of all, you start a new notebook for the night of the death. Also, the police open it up to like, Dear Diary, the night my husband died. Jolene said, is this the sequel? The dog has already been walked. I think this is the prequel. The first 5 pages of the notebook contain the defendant's handwritten journal detailing the events of March 3rd and 4th, the night of Eric Richins' death. We're gonna see a lot of what the defendant has to say, even if the defendant doesn't testify in this case. Because the defendant also gave multiple interviews to law enforcement. Remember, she was not arrested for a year. The state says that the orange notebook is, as the state claims, a journal written by defendant. The defendant has admitted that she wrote the orange notebook. Moreover, the writing is the defendant's handwriting, and the journal contains information that only the defendant would know. Remember, they have talked about a handwriting expert, but also they have this. I would imagine that the orange notebook probably looks similar to this, maybe written in pen, not pencil. That's the wrong motion. They go on to say it's not hearsay, right? It's written by her. The orange notebook is relevant. I'm going not to the law on this because relevance is a pretty low bar, as they argue. They say the first 5 pages of the orange notebook are relevant because they provide the defendant's first-hand account of the night of Eric Richins' death. They contain certain details regarding timeline, the defendant's movements, what Eric Richins consumed, among other relevant details. These details, especially when compared with other evidence in the case, tend to make it more probable that the defendant poisoned Eric Richins with fentanyl. You don't say. You don't say. So, they say that the probative value substantially outweighs the fear of prejudice. Well, yes, if she's writing about the events surrounding the death of her husband, it's going to be probative. It's also going to be prejudicial. But the value to the jury is not going to be outweighed by just about anything. They cite the same law that they cited in the last motion, so I'm going to zoom to more details about the orange notebook. The argument is here, the first 5 pages of the orange notebook are probative for the same reasons they are relevant. Nothing about the first 5 pages is unfairly prejudicial. They do not appeal to the jury's sympathies, arouse a sense of horror, or provoke its instinct to punish. The first 5 pages do not describe or delight in Eric Richins' death. Nobody forced or coerced the defendant to write the orange notebook. The defendant holds a master's degree. She journaled, risking the likelihood that detectives would find it and recognize it for what it is. Any prejudice is entirely fair and well earned. And then they talk about the 403 balancing test, saying that the orange notebook is highly probative because it bears directly on defendant's agency in Eric Richins' death. So she journaled about the death of her husband. The defense, I imagine, is going to argue, well, we don't know when this was written. And the prosecution is going to say, doesn't matter when it was written. She's detailing what happened that night. So it doesn't matter how close in time to that night she wrote it. She wrote it sometime between the crime happening and her being arrested. So she wrote it within a year of when it happened, unless she dated the page. And she might have dated the page. Who knows? But they argued, the defense had argued during suppression motions to keep this out. It was not kept out at suppression. So it was, there were questions about whether this was improperly seized or not. I believe it was in plain sight, and then they went back with another warrant for it. However, there was a lot that went on in those suppression hearings. So I don't remember if the ruling was because they went back or if it was inevitable discovery, because it could have also been that, well, no, they arrested her. They took her out of the house. She wasn't going to be able to get back into the house and destroy it. So when they got it and then went into it, it was inevitable that they were going to get into it based on the fact that they had seen it there. So either way, it was not suppressed. The defense argued mightily to suppress the seizure and search of the orange notebook and the things in it. And that's not what the court did. So the court, what we can tell based on the minute order here is that the court said that this was going to be subject to, essentially the same restrictions that we saw in other things, where when they're talking about docket 917, which is the motion regarding the orange notebook, sorry for constantly moving the page, that they argued about foundation. They argued about declarations They argued about pre-admitting. And then it seems that the court rules that at trial, the state needs to make a showing. So a showing of foundation, I suppose. Let's see. Moving on. Counsel for the state, Bloodworth, addresses the state's motion to admit defendant's interview docket. And that is the defendant's interview statements and email. That is docket item 1163. There's a typo here that says 1116. It's not that item. And then the court deferred ruling to allow a surreply. So the arguments over the statements and email are going to have a further reply. When, and I have not seen it yet on the docket, when we have that further reply, we will probably cover it closer in time to this going to trial. Let me see if I have docket 1163 because my brain is fuzzy if I had it or not. We do. Let's look at 1163 real quick at the state's arguments. And then when the defense puts in their surreply, I will grab the defense's reply here. We have watched a lot of these hearings on the defense motions. Sorry, this is pulling up weird. And let me just, why do you split screen? No, the tech was fighting with me. So I am only pulling up what the prosecution says that is in these items. I am not pulling up all of the defense's arguments against these items. The defense arguments are going to vary from not relevant, not authentic, improperly seized. And we saw all of those arguments in those hearings that we covered together. So it is a one-sided perspective that we are getting at the moment of what the prosecution says these items are. And I am looking at it for the perspective of what is this docket item and what is the court doing in court, not balancing the arguments between the parties, because ultimately what comes in at trial is what I am most interested in. So that's why I'm just grabbing the prosecutor's statements of what these things are. When we get the defense surreply on this, we will take a look at the full pleading of these. But also a lot of the law on these is boilerplate. The arguments are boilerplate. It's not authentic. It's not relevant. It's not admissible. It was improperly searched. It was improperly seized. And so the court ruling on that is really what's most relevant for our purposes. So that I wanted to clarify why I'm just grabbing the prosecutor's statements on these. So, and we already saw all the search and seizure motions. And we also saw the, what am I trying to say? Apologies, chat. Girl, sometimes we need a day. I know. Don't worry. We'll feel better soon. But we've seen some of the defense arguments that we have spent a lot of time going through, and the arguments weren't even grounded in reality of what the thing was. Like, the arguments were just so outlandish. I was like, this isn't even helpful. Truly. Like, the stretch was so much of a stretch. It just wasn't helpful going over. And I don't think I have the energy to do that today. Truly. So this is the arguments regarding defendant's interview and interview statements and email. We saw some of this in the suppression hearings, and those will be linked in the playlist below if you want to go back and watch the suppression hearings. That's right, Lyndon. Thank you. Lyndon said Bloodworth straight up admitted the warrant didn't cover the notebook and that they'd be arguing inevitable discovery. And we didn't see all the rest of those hearings. They weren't all televised. Which is also hard because we have pieces of it. But yes, I imagine the notebook would have been inevitable discovery because, every girl boss needs a notebook. Dear diary. I think journaling is a very helpful practice. Self-snitching, on the other hand, not so helpful. Do any of you guys know if we have seen, has this case been covered at all? Has all of the self-snitching been covered at all by Bruce Rivers? Anyone? Has he covered the self-snitching that is Kouri Richins? Maybe he'll wait till trial. Between the walk the dog letter and the journaling and the jail calls and the book and the rest of it, like, this is so much self-snitching he did. I need to go look for it. When it goes to trial, I imagine we'll see him talk about it again. It's so much self-snitching. So much. All right. Relief requested. The state requests the court pre-admit defendant statements provided to detectives during an interview on April 14th, 2023, and an April 17th, 2023 follow-up email to detectives. I don't remember the follow-up email to detectives, so I'm curious about that. I do remember the interview, and we heard quite a lot of it. The police went to Kouri's home and like sat in her living room and set up just a recorder. It's not video recorded, but set up just an audio recorder. They go on to give a statement of relevant facts, which is what we have been looking for. Detectives interviewed the defendant at her residence April 14th, 2023. That interview was contemporaneously recorded and transcribed. The state proposes to admit these things. The interview contains 6 distinct statements. 1, Eric Richins' health history. And then they list in this, if you're looking at it, they list in this the page and line of the transcript in the interview that they're talking about. She talked about the night of Eric Richins' death, phone deletions, text messages, photos, and things like that. Phone deletions, the Eric Richins living trust, life insurance, power of attorney. They say the defendant's statements from the interview the state is requesting to pre-admit are in docket 1159, which is sealed. The state is not seeking to admit the portions of the interview redacted in yellow. What I appreciate is that the state highlighted for the court in yellow what they're proposing to redact so the court can see it, instead of giving a redacted copy and letting the court play like hunt and find with like the redacted and unredacted and be like, okay, this line and this line. It is, I think, a good practice. Not everybody does it that way. I appreciate it. They're like, no, we highlighted in yellow the proposed redactions so the court can see it. They argue it's authentic. Yes, they sat down and interviewed the defendant in her voice, not hearsay, relevance. I want to see if they give us any more information about the email. The defendant's interview and email statements contain certain details regarding to the defendant's means, motive, and opportunity to cause Eric's death. The details, especially when compared to other evidence in the case, tend to make it more probable that the defendant poisoned Eric Richins. Let's see. They go on to say that the defendant's statements are complete. So the defense, I wonder if they are arguing partly rule of completeness, like you need to put in the whole interview. I'm sure they're going to say, fine, put in the whole interview then. However, the prosecution might have a circumstance where they're like, no, some of these things need to be redacted. And if the defendant wants to admit those, they need to come in and testify to it. Remember, when you are looking at the statement of a party opponent, the prosecution can pick what statements of the defendant to put in. The defense can't do the same. So if there was an interview that the defendant gave and the defendant's interview was all like what they think a defense might be at trial, the prosecution could choose not to admit that interview at all, period. They could choose not to use it. And if the defendant wants to use it, the defendant can sit on the stand under oath, be cross-examined, and say whatever they want to say. But what the defense can't do is say, I want this interview in, and then admit that interview and put it in. So if the prosecution chooses to use an interview and wants to use only parts of it, then the defense can argue not, well, we want all these statements in. What the defense can argue is, well, we need it to be more complete. We talked about this a lot in the Karen Reed case with Karen Reed's interviews to the media. If the prosecution can cherry pick statements, can't the defense put in the other statements? No. But they can argue that the statement is out of context and you need more to complete it. So I wouldn't be surprised if we saw the defense arguing completeness. The defendant cannot put in their own statement. They cannot. They have to choose to put it in. So they have to choose to put it in through testimony. Sorry, the end of that sentence didn't help. So the prosecution can put in parts of interviews. The defense can't put in alternate parts of interviews. They can only ask for completeness. I want to make sure I'm clear because, again, under the weather. Does that make sense? Hopefully so. Getting back into this, the prosecution starts arguing completeness and saying that the interview is complete, that the statements are complete. They can't just clip things out of context to present a misleading impression, but they don't have to put it all in. If the defendant gives the rundown of what happened that night and then gets into all of their excuses, they can cut that part out and say, if you want to testify to all these excuses, come in and testify then. They go on to say that the defendant's statements from the redacted interview and email that the state seeks to admit do not create a misleading impression. The remainder of the interview and the email is not necessary in fairness to clarify, qualify, explain, or contextualize the statements. Accordingly, the defendant's statements are complete. So they are looking to put in a somewhat redacted version of what the defendant said. The defense can argue for completeness. We'll see what the court says. They say that the court should pre-admit for trial the redacted recording and redacted transcript of the defendant's statements in the interview and then in the follow-up email. Let's see what the court says regarding that, because we are dealing with docket 1163, and the court is allowing surreply here. Emily, you already forgot that you said that earlier. Yes. So the defense will have another opportunity to argue, and the defense might want to put in some more law and be arguing here, look, Your Honor, if you're going to let in this whole interview, you should let in the whole interview. All of it. So they're moving on. Counsel for Bloodworth addresses the court. The court will defer ruling regarding the yellow portions, but all others are admissible. So the court is not ruling about the redactions yet. The court said everything that's not redacted comes in. Of course it's going to come in. It's the defendant's own statements. But the court is saying we will have more argument regarding the redactions. I imagine the defense wants all the redactions in, and the prosecution's like, no. Look, come testify then. It goes on to say that counsel for the defendant, Nestor, addresses the court regarding the authenticity of jail calls at docket 1165. I think 1165 is one that is under seal. Let me double check. No, not under seal. All right. This is not helpful though, but we're going to look at 1165 real quick because they are seeking to admit parts of defendant's jail calls. They're going to spend days on the defendant's statements in this case. This is days of testimony. Days and days. All right, let's go look at docket 1165. This is the state's motion to determine the admissibility of defendant's jail calls and text messages. Yes, the defendant has a device where they are able to text. Remember in the jail call that we talked about the last time we talked about this case, the defendant was complaining because she wasn't allowed to text or write. She could only do recorded calls, and she wasn't allowed to do video calls because she was writing the walk the dog letter, and they said she was holding letters up to the screen so that she didn't have to verbally say what was on the screen, because on the recorded jail calls, she's the one recorded, not the other party. Yeah. All right. This is the prosecution asking to admit jail calls and text messages using the account that they use for that. They say that the calls are recorded and transcribed. These are the calls they want. All of these are sealed. So it looks like states 69 through 98. The defendant's statements from those calls and text that the state is requesting are listed below and provided to the court on thumb drive and defense counsel in the box, which is their like Dropbox that they're using. And the state is not seeking to admit the portions of the calls redacted in yellow. The defendant's jail calls and text messages contain certain details regarding her procurement of quote unquote pain pills from Carmen Lauber, her knowledge about quote unquote what happened after she went to bed on March 3rd, the toxicology of Eric Richins' body, Valentine's Day 2022, Eric Richins' attitude about suicide, the witness Hayden Jeffs, her consultation with a divorce attorney in 2021. What did you say? Her consultation with a divorce attorney? She was on her jail calls talking about her consultation with a divorce attorney in 2021? Oh, that's new information. We know that he did. We didn't know that she did. Oh my God. You guys. That's interesting information. Here's why. The argument from the prosecution is that, or in part, that the defendant knew that if she divorced Eric Richins under their prenuptial agreement, she wouldn't get part of his business, the house, or most other things. Now, I think there is room to argue if you're the defense. Kouri Richins was in love. She knew there was going to be a prenup about his business, and she was like, blah, 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 business, business, business. I'll sign it. I'm ready to get married. She was just a girl standing in front of a boy, ready to get married in a big white dress and be the envy of all of her sister-in-laws. She wanted to do all the things. So yeah, there was a prenup, but she didn't really read it, and she didn't know what was in the prenuptial agreement. Like, she didn't go look at it. I don't remember the year that they got married. I have the prenuptial agreement though we have the prenup in one of these cases because it comes up in all the civil litigation that's going on in the estate case. So I could go find the date of that. However, I worry if I derail that we're never going to come back to this. But the argument would be that they were, married well before this. Who even remembers what's in those like legal documents anyway? It's like blah, blah, blah. You just, you sign it. You don't really read it. It's fine. Who even knew? She didn't know. And a huge part of the prosecution's argument here is that Kouri Richins was aware that if Eric Richins died while they were married, she gets the house, she gets, Emily, don't start quoting Taylor Swift, she gets the house, she gets half the business, she gets all the money, she gets the life insurance and the rest of it. But if they divorce, she doesn't get his half of his successful business. She doesn't get the house that is in only his name. There are things that she does not get. But if she's talking to a divorce attorney, the thing a divorce attorney would say is there a prenuptial agreement? Let's look at it and talk about it together. It makes it easier for the jury to understand that this was on her mind leading into February 2022. That she had that conversation. The prosecution could also argue, depending on what information they have, that when she met with the divorce attorney is when she started thinking about, what's the probability my husband might just have a heart attack? Am I going to be able to fight with this prenuptial agreement? Or if I get divorced, am I screwed? If I get divorced, do I have no access to any of this? Is the only, the prosecution, I could see them arguing, Kouri Richins consulted a defense attorney and then came to the realization that the only way to get the money that she wanted was if Eric Richins died. And then she went, well, how do people die? Oh, fentanyl's killing a lot of people. That could work. I mean, I can see the argument because there's no other way to really tie that together unless she's talking about it. And we have no way to know that she's consulting with a divorce attorney, but then she says that shit on a jail call. Oh boy. That's interesting. And she's also talking about other witnesses. And she's also talking about the transfer of the mortgage of her mom's house. Oh boy. Apparently she's a talker. I've seen a lot of you noting that YouTube's being weird. I've also seen the news that there are some pretty significant internet and cell phone outages today. So if your YouTube is being weird, I apologize. Replay crew is always here for you. Emily, does her talking about her conversation with her attorney violate attorney-client privilege? Yeah, it does. It really opens up conversations about the attorney-client privilege. She's definitely a talker. She's a talker. Dude, I don't understand. And this happens all the time. And I guess I'm glad I'm glad it happens because it's incredibly helpful to prosecutors. But prosecutors don't know any of this unless you talk about it on a recorded line. Your defense attorney can't just come into court and be like, oh yeah, Kouri and I had a chitty chat and this is what she said. Their attorney-client privilege prevents them from doing that, even in a murder case like this. So, oh my God. But if you're talking about it on a jail call, well, they're going to listen to every single jail call. And they're not even going to be mad about it. Because you're talking so much shit on the jail calls. Bloodworth or somebody in the office is sitting there going, oh shit, I can't believe this. All right, so the jail calls. She's talking about, she's telling them everything, including the mortgage fraud. So, I saw YouTube Kim said, Emily, why would she keep a journal? She really thinks it's untouchable. Kim, this is a great question. It was part of her morning routine. She was on a path to be that girl. So after she made her morning matcha and did her, yoga with Adrian, she sat down and journaled about her feelings because it was part of her self-care. Now, I think journaling is great. However, this context is not helpful for her. Real helpful for the prosecutors, though. Real helpful for the prosecutors. Clithy says, I imagine someone enjoys listening to her jail calls just because. Yeah. I was never mad listening to jail calls. There were times I really was like, oh God, I was subjected to this. But I was not mad listening to jail calls. Even when they were talking shit about me, I was like, and then you go back into court and you're just like, hey there. The best part about jail calls is very much like a reality show. You learn everything that's going on. Linda said, doesn't it say at the beginning of the jail call that this will be recorded? Yep. And then it beeps throughout the jail calls. Like, Yoga with Adrian is amazing. Isn't that what we're doing? Just me? No, all of you too. People know that the jail calls are being recorded. They don't think anyone's listening. Okay. But the thing about jail, there was a case I had where the jail calls basically turned into like days of our lives because dude in custody had a very full roster. And everyone thought they were at the top of the roster. But then he was also trying to navigate who was coming into court on what days so that the roster would not be aware of each other, and who was putting money on the books, who was taking things out of the home to hide them, and who was doing what. The problem is that the detectives, myself and others, were listening to all these jail calls. And so that's an awful lot of leverage that the detectives have. And so when the detectives went to interview, say, the person who had removed digital devices that were, hey, are you keeping the thing safe in the place? Like, oh, hey, do you know who so-and-so is? In the interview, hey, we need to ask you some questions. Do you know who so-and-so is? Excuse me? Oh, no, but do you know who so-and-so is? Because we know that, like, so-and-so was with your man and they were talking about this and that. But do you know who that is? Like, we're trying to kind of figure it out. And then you watch people lose their mind. The inverse is true sometimes, too. I have, sometimes they will, well, in the Adelson case, they called it tickling the wires. But sometimes the detectives will let a little bit of information out and then see what the phone calls are like after that. So it is, it's always interesting, but trying to keep the roster coordinated so they didn't all run into each other in court was a very interesting thing. A very interesting thing. Some of them were being told wrong court days. Like, oh, no, I'm not going on Tuesday. I'm going on Thursday or whatever. It was wild. And then trying to keep up all of the different parties was much. And then it got into the like other types of activities on the phone that none of us can unhear. None of us can unhear them. All right. Back to the jail calls where the defendant is talking about her conversations with her divorce attorney. That's a terrible plan. But I can't wait to hear some of these jail calls. Emily, you said in the Adelson case, I can't wait to hear these calls. And like 30 minutes in, girl, you were like, oh my God, Charlie, shut up. Yes, I was. The same thing might happen here, but I want to hear all of these calls. Let's see if there's any new information in these. The prosecution says that the defendant's jail calls and text messages contain her matter-of-fact narrative. Excuse me, Mr. Bloodworth? Like, it's not a narrative, okay? It's a novel. It's not even like a letter, like, because the level of like Valley Girl uptalk I imagine to hear on those jail calls is going to be much. Just based on what the transcripts look like, I can imagine the like millennially Kardashian-ness of it all. Like for real though, Maybe we'll be surprised. Defendant's jail calls and text messages contain her matter-of-fact narrative, deadass, discussion and opinion regarding details probative to defendant's means, motive, and opportunity to cause Eric Richins' death. They're not inflammatory, shocking, or misleading, except to the extent that the defendant is deliberately misleading to cover up her involvement in Eric Richins' death. The prosecution triggered. The prosecution's like, it's kind of shocking and misleading because she's trying to deliberately mislead the cover-up, but it doesn't mislead the jury. The jury can clock it, Your Honor, like immediately. Oh, let's see what else they're arguing. They're arguing the statements are complete. The prosecution says the defendant's redacted jail calls and text messages do not create a misleading impression. It might not be a favorable impression, but it's not misleading. Defendant's redacted jail calls and text messages do not create a misleading impression. The remainder of the calls and text message strings is not, in fairness, necessary to clarify, qualify, explain, or contextualize the statements. So this is what the prosecution, in a overview, thinks those calls will contain. There's definitely some new information in there. The witness, the consultation with the divorce attorney, Eric's thoughts. Why would the victim's thoughts about suicide come up? Well, if the defense is trying to argue at all that this was not an accidental overdose, but an intentional overdose, the defendant talking about that would be completely relevant. If the defense is going to try to make that argument that people overdose, sometimes accidentally, sometimes intentionally, but she didn't kill him. So when we are talking about docket 1165, that's what we were just looking at, that the jail calls will come in. Miss Nestor addressed Miss Nestor addressed the authenticity of the jail calls. Bloodworth addressed the court addressed the parties, is not prepared to determine the relevance in 403 issues. So the court's not going to balance this statement comes in, this statement goes out, but these are authentic. Jail calls regularly come in. So jail calls regularly come in. Let's see. I see some of you in the chat asking, can Kouri waive attorney-client privilege for her divorce lawyer to come in? Yes. If Kouri thinks her divorce lawyer is helpful to her, Kouri can waive that privilege. The divorce attorney can't waive that privilege, and the prosecution can't go subpoena the divorce attorney and be like, tell us what you know. The divorce attorney is going to be like, that's privilege. But if Kouri waives the privilege, Kouri can bring her defense attorney in. Yes, she can. And there are limits with regard to the attorney that Eric Richins met with, because that privilege carries on even though he is deceased. I think this has never come up in my practice. I have not thought about it. I have not researched it. But I could see a circumstance where, in this case, like Eric Richins' divorce attorney could come in and say, in representation of my client's best interest and rights, I cannot tell you what my client and I spoke about specifically, but I can say that Eric Richins came and saw me on this date and that we made changes to his will and trust in this way, that we discussed what dissolution of the marriage would look like without going into more detail, and that these things were done. So there is a narrow circumstance where, even though attorney-client privilege would follow the client even if the client was deceased, I could see an attorney seeking ethical guidance on how much can I disclose in protection of my client's estate and trust in representing them, even when they are deceased, in the context of a murder case and in the context of the ongoing civil litigation, because there's numerous civil litigations. I mean, they've all been kind of lumped into one court before this judge, but there's numerous civil litigations going on with regard to Eric Richins' estate because his estate was changed. And it seems that Kouri Richins, based on everything that we've seen, Kouri Richins had no idea that Eric Richins changed his will at all. So we might see testimony that Eric Richins' will and like life planning was changed. Some of those changes indicate that he was concerned. So I think we'll see some of that because what is the date of that? Hold on. I have that in, no, that's probably buried with the prenuptial agreement. Let me see if I have it. Oh, this is the will. Let me see what date this is. I'm looking at the will of Eric Richins just real quick to see when it was signed. This was changed August 19th. No, that was certified then. That's not when it was changed. Wrong date. Because that's notarized. Where is the date on this? Oh, here it is. Okay. Let me just pull this up. I think it'll be easier to just show you. I just didn't want to confuse the notary stamp because the notary stamp has a date that's after the date of death on this, and I didn't want to confuse things. All right. So the changing of the will was signed on November 3rd, 2020. The facts leading up to this involved financial things that were going on, but November 3rd, 2020 is when this happened. I think that there was some conversation around whether this was changed after February 14th, before he was killed on March 3rd, 4th. It happened before that, and I just hadn't pulled it up. But the will was changed in November of 2020, leading up to this. But when we're looking at November 2020 of the will being changed, and then we're looking at, no, that's the walk the dog letter. Let's see where, and then we're looking at Kouri potentially consulting with a divorce attorney in 2021. We're looking at kind of the end of 2020, the will changes on Eric Richins' part, which, based on everything we've seen, had to do with a confrontation around money. Then we're looking at Kouri Richins talking to a divorce attorney at some point in 2021. And then we are looking at this attempted murder and murder happening at the beginning of 2022. So these things are not that far apart in time. We've got that year of 2021 where stuff is happening, but he knew something was up with the money in 2020 and changed his will so that Kouri Richins was not in charge of everything, and his sister was in charge of everything, and that everything went to his kids with his sister being in charge of the estate and what have you. So that was in 2020. All right, back to the court docket and looking. We are now going to start looking at issues that are all sealed. So when we're looking at this going to trial in 2026, the death in this case happened in 2022. So from the end of 2020 to the very beginning of 2022, because he was killed in March 2022, we're looking at a year, less than like a year and a half of time passing, which is truly not a huge amount of time in a busy life with young kids. It's just not that much time. I'm interested when Kouri Richins had that conversation with her defense attorney or divorce attorney consultation. That is new info. I'm very interested about that. I guess we'll see at trial, won't we? Okay, so they move on to the state's motion to exclude evidence that the victim committed assault, docket item 1167. That docket item was completely filed under seal. We know nothing more about it. We've heard the defense attorneys allude to it a couple times. And the court simply says, for reasons stated on the record, grants the state's motion to exclude evidence that the victim committed assault, docket 1167. I don't know what the defense attorney was trying to allude to, but this is a poisoning case. This is not going to be a self-defense case. We are not going to see defenses like we did in Sarah Boone. So this attempt to say anything about the victim in that way has been thwarted. That will not be coming up. The court granted the state's motion to exclude what the defense wanted to bring there. They then move on to 1168. The defense objected to the state's motion to exclude evidence that the victim abused drugs in high school. First of all, I'm not quite sure what the defense means by this, but if the defense is characterizing, and I could imagine that this could happen in this case, the victim like smoking weed in high school as grounds in this case, I can't imagine it's even relevant. So, Griffin said, wait, this case isn't going to trial next year. No, we're in 2026. Did I not say 2026? No, it's going to trial next month. We're in 2026. Which is still hard for my brain to wrap around that we're in 2026 currently. I know, it's wild. But if they are trying to say, look, Eric Richins smoked weed in high school, therefore he was abusing fentanyl, it's too removed, it's too detached, it's too remote, and it's too unconnected. And again, they tested gummies that were found in the house. And I don't know if they were CBD or THC or a combination of the both, but they tested things that were located in the house and none of them had fentanyl in them. Law enforcement actually tested things. So, okay. So the state is seeking to exclude information that the defense said they were going to bring in trial. Bloodworth addressed the court. Ms. Nestor argued to the court. The court spoke to the parties. The parties spoke back to the court. It goes on to say the court addresses the parties and indicates it will defer ruling on the motion at docket 1168 pending the offer of information outside the presence of the jury at trial. So the court reserved ruling, saying essentially, we will have to see if this organically comes up. And if this comes up, the defense is going to need to make a showing outside the presence of the jury before you can bring it up. Do not mention it until we talk about it outside the presence of the jury, which is fair. But if the defense is going to try to say that the victim took fentanyl on his own and this is an accidental overdose, this could become relevant, but it might not. They go on to say that counsel for Bloodworth addresses the court regarding defendant's motion in limine regarding the book. Counsel for defendant, Ms. Nestor, addresses the court regarding defendant's motion in limine regarding the book, docket 1208. Let me just double check. I think 1208 is also sealed. I'm going to pull up the docket. I'll show you what I mean by that. Let me just get to docket number 1208. This is a, we like them big and something, something. This is like a moto type of docket. There are so many docketed items. All right, I'm going to show you guys this docket real quick on where we're at. So when we're talking about docket night item 120, oh, you can't see the numbers. Hold on. You can see where it says like 1207 and then private. Those are all the motions in limine that are filed privately, and we don't even have a docket number on them. So MP means non-public. You can't access those. So we can see that on the docket, these are all things that are filed that we cannot see. So we don't know. I mean, we know what the court is telling us, and that's about it. So as we are getting into docket number 1208, Ms. Nestor addresses the court regarding a continuous objection. Bloodworth addresses the court regarding the cover of the book. What book are we talking about? Well, this has come up in the civil case as well. Of course, Kouri Richins wrote a children's book that's no longer for sale. Let's see if I can find an image of the... Oh, yeah, there's plenty of them. All right, well, that makes it easy. Nope, that's behind a paywall. Give me 1 second to find a non-paywalled story that I can show you. This is in the civil lawsuit as well, because in one of the civil lawsuits regarding the estate, it's not in the actual story. Ugh, I hate it when news organizations do that. It's in the metadata, but not in the story. With the, let's see if it's in this one. Yep, there it is. All right. Of course, we rely on people to go find it. So in the civil case, there is that's me. Apologies. There is an allegation. That's not you. That's me. There is an allegation in the civil case that Kouri Richins was improperly using Eric Richins' likeness. And that has come up in some of the civil case that we've covered. This is the cover of the book called Are You With Me? This drawing of Eric Richins with an angel halo and wings is Eric Richins. It looks like there is a kid on the cover playing soccer. So that is part of the children's book, Are You With Me? She was on local media talking about the book before she was arrested for murder. The book is no longer being sold. The book is no longer available. So the book is the book. So with that, this article, when is this article from? This article is from August 30th, 2023, ahead of this going to trial, with photos of Kouri Richins, Eric Richins, and their kids with their faces redacted, which is appropriate, and I appreciate it. And then they go on to detail Kouri Richins talking about the book in this article, saying, eyes reddened by crying, mom and aspiring children's book author Kouri Richins joined a Zoom business meeting with ghostwriter Shane Walter late last year from her home in Camas, Utah. The newly widowed 32-year-old parent of 3 young boys, her husband Eric, 39, had died suddenly months earlier, wanted to hire Walter to work on a children's book she was planning to publish around the anniversary of Eric's death, based on her own family's story. There's new information in that I was not aware of. Hopefully you're with me on the side quest. Yeah, no, she seemed to get a ghostwriter and was going to release it around the anniversary of his death. Okay. So Walter's interviewed. Side quest. We've officially side quested, chat. We're here now. We're here now. We're here now. Here we are. Because they interviewed the ghostwriter. And I want to know. The ghostwriter said she was all alone at that point, says Walter, adding that Kouri often teared up while talking about her husband and the boys. She was doing everything that a mother can do. I mean, I have suggestions, but I'm going to keep those in my brain for now. So this is the cover of People magazine and the date on it, September 11th, 2023. She wrote a book on grief after her husband died. Did she kill him? That's a fair question. But just months after the publication of Are You With Me, a book featuring a boy dealing with grief over the loss of his father appeared on Amazon and began racking impressive sales, Kouri was arrested and charged with her husband's murder. Prosecutors say the deeply indebted real estate agent, who owed creditors more than $2 million, served Eric an evening cocktail laced with 5 times a lethal dose of fentanyl, which they say she had procured from a housekeeper moonlighting as a drug dealer. I mean, she was the go-between. The go-between was the go-between. They had worked together and it was like, hey, do you know a guy? And the go-between was like, I know a guy who knows a guy. I can get that for you. I don't think, we'll CL also has a record that we will hear about. This was not the first run-in with the law CL had. CL knew enough to know a guy to get a guy and also knew enough to take a deal, but we'll hear more about that because I imagine the defense is going to try to say CL is completely unreliable. But we'll see. Anyway, potato on this. They go on to say that the impetus for that was to collect on at least 5 life insurance policies she'd taken out in his name, and which would more or less cover her debts. But in interviews with people, friends of Kouri's say the Utah soccer mom is innocent of her husband's March 4th, 2022 death, and that the evidence prosecutors have used against her has been taken out of context. You guys, she's just a normal soccer mom. There's a lot that will come out at trial, a friend close to the case says. I'm certain that once it does, the jury will make the right decision. Was this before the preliminary hearing? This was before the preliminary hearing, I think. Maybe it wasn't. We'll see. But there's a lot that's going to come out at trial for sure. They have a wedding picture of Kouri and Eric. They go on to say Kouri, who worked as a housekeeper through college, often felt an outsider in Eric's affluent ranching family. I don't know about that based on the walk the dog letter. It goes on to say about a year after the birth of their first son, the couple married in a backyard wedding in June 2013. Shortly before Kouri walked down the aisle, decked in her wedding gown and pearls, Eric's mother presented her with a prenup, barring Kouri from claiming Eric's 50% stake in his stonemasonry business, except in the event of his death, according to the civil suit. I do not know if that happened the day of the wedding. There are quite a lot of rules around that. You can't just be like, oh, hey, right before you walk down the aisle, surprise, here's a prenup. There are rules to that, but that's not what the trial is going to be over. There is a prenup. Let's see. They said the couple, there's words missing in this sentence. The couple's relationship came to a head when Kouri decided to start a real estate business a few years ago. Kouri told investigators in an email sent weeks before her May 8th arrest that, is this the email that they want to put in? Because the email that they want to put in is from April 18th, 19th, right before her arrest. Eric wanted us to live the typical conservative life where she's like, I didn't want the trad wife life where the man takes care of the family and the wife is a homemaker, wife and mom, and that's it. That's not my personality and not the way I was raised. Kouri said in the email, adding, I wanted to be more. Well, I mean, this was not the way to go about it. Kouri said in the email the couple had worked things out, a statement supported by friends of both Eric and Kouri. Throughout the investigation, as, quote, all of this stuff hit the fan, a close friend of Kouri's recalled being surprised that she was still wearing her wedding ring. Quote, I just miss Eric, he recalled Kouri saying. Well, we know some of the things that Kouri did with her friends because we saw that one of her friends trusted Kouri to get her a home, and that failed spectacularly. So more information has come out since then. Characterized as the ultimate quote-unquote family man in his obituary, Eric was a member of the Church of Jesus Christ of Latter-day Saints. We knew that. We saw it in the Walk the Dog letter when Kouri's like, he hasn't even gone to church. He had gone on a 2-year mission to Mexico City. That makes more sense. Well, maybe it's not as random as it had seemed. That's some new information. That explains why Kouri in the Walk the Dog letter, hold on. This fills in the gaps a little bit that his mission was to Mexico. That in the Walk the Dog letter, they wanted to build a connection to Mexico. We need some kind of connection. Well, that makes sense. I was wondering why they were so just like, we need to make a connection to Mexico. We need to make this connection to Mexico. It makes sense that the victim has a connection to Mexico and lived in Mexico for 2 years. It still doesn't make sense that she was saying that in her book there was this big 4th of July party while they were in Mexico, but whatever. New information, according to people. things that probably won't come in trial, but at least it makes sense to us that now we know. And for those of you that do not watch, well, anything connected to lives of Mormon wives or others, missions are really common within the church. They can be within the country where you are from, outside of the country where you are from. They go through a whole lot of language courses before you go to the country, if you were going out of the country, etc. So that, I think it's a whole thing is downplaying it, but it was a whole plot on Real Housewives of Salt Lake City, where Lisa Barlow's oldest went on his mission to, I think, Colombia. So anyway, a whole thing. Either way, it makes more sense that Eric went on his mission to Mexico City. They go on to say, those closest to Kouri say Eric was also a man who had strayed from the church and began drinking and taking illegal drugs during the marriage. Wasn't she having a full, affair, though? Didn't she also stray? Because if they're going to throw Eric under the bus, let's just make sure that we're all under the same bus here. Because Kouri was also drinking not swig, because she was making alcoholic beverages for both of them. Okay. Sure. All right. You guys know how I feel. I yelled about this during the last time I covered the Walk the Dog letter. I'm just going to leave it there. But they are saying that Eric had strayed from the church and began drinking and taking illegal drugs. Apparently, Kouri was drinking and having an affair. So, they go on to say that, friends of Kouri go on to say that Eric's family never liked Kouri. I mean, we read the Walk the Dog letter. I can't imagine that they weren't all thrilled with one another. I'm so shocked. And that they want to believe Eric was perfect in every way, that Eric couldn't have died in any other way besides at Kouri's hands. They go on to throw the victim's family under the bus, which I just hate everything, saying the family needs an answer, someone to blame, adds Kouri's best friend. I believe Eric must have died from an accidental overdose. Then why wasn't any fentanyl found in the house? Just asking. They go on to say that prosecutors say that hours after her arrest, in a recorded jailhouse phone call, Kouri told her mother and brother that Eric asked her to purchase pain pills for him and suggested that the drug dealer had sold her fentanyl instead. Look at how much this ties back together to what we were just talking about. Because that was one of the things in the jail calls that the prosecution wants to bring in. How does people know all of this? I wonder if they got it from the defense filings. I'm curious how people knew all of this, but that's what we were just talking about in the jail call filings. That Kouri told her mother and brother that Eric had asked her to purchase pain pills. Okay. They go on to say a fentanyl-free cocktail glass could support Kouri's defense. I mean, was it Kouri's cocktail glass? A fentanyl-free cocktail glass could support Kouri's defense, and in early pretrial hearings, Kouri's lawyers, who were gagged from talking to the media, have honed in on the cup in question. At a bail hearing in June, the lead investigator testified that law enforcement never tested an empty cup for traces of drugs. Kouri mentioned the drink to investigators the day Eric died, according to a dated written statement she made to the sheriff's office. Kouri, who faces between 25 years to life in prison without parole if convicted of her husband's murder, is studying for the LSAT and hopes of becoming a defense lawyer for people unjustly accused. this was old, that her trial date had not yet been set and a hearing for the case was slated for September 1st. We know from Kouri's phone that she was moving around a lot before she called law enforcement. So I think we're going to learn more about the cleaning up of the house at some point. Also, she wasn't arrested for a year. So there's that. All right. Well, thank you for joining me on the little side quest. There was some new information we learned in that I think is helpful. And it really was... No, Emily, you can't. Yes, you can. It was really on all fours with what we were just talking about. See, because the walk the dog letter. So back to what the court decided, that the court ruled regarding the book. The defense has a continuing objection regarding the book. Bloodworth addresses the court regarding the cover of the book, and the court rules as stated on the record. That is the most annoying ruling. The court rules as stated on the record, the sealed record. Is the cover of the book coming in or not? Well, I guess we'll find out when we get to trial. There will be some surprises, even though we've been covering this book from the beginning, because this is all sealed. Counsel for the defendant, Ms. Nestor, addresses the court regarding the interview as a whole. Mr. Lewis or Miss Lewis then addresses the court. The court addresses the parties. There's a 10-minute recess. Nestor addresses the court regarding a private filing. Counsel for the state, Bloodworth, addresses the court regarding the defendant's motion in limine, docket 1208, part 2 and 3. 1208 is sealed. So do we know what 1208 is? No, I don't even know if we have a title for 1208. 1208, non-public motion in limine, A, B, and C. Yeah, we don't have any more information about that. So helpful. Thanks, Your Honor. Let's see. The parties address the court. They start talking about the home equity line of credit taken out on the house. Remember, it is believed that that was forged and without the victim's knowledge until the victim found out and then went and changed the will. The court rules for reasons stated on the record that the defendant's motion in limine regarding part 3 is denied and is excluded. So the defense was asking to bring something in. The court said no and excluded it. States exhibit TI and T2 or T1 and T2. There should be a comma here. So whatever part 3 is was excluded. States exhibit T1 and T2 and then granted defendant's motion in limine part 2. I guess we'll see. Bloodworth requests clarification. The court addresses the parties. We don't know what any of this is. They are then getting into the other parts of those docketed items that we can't see. The court, for the reasons stated on the record, is denying the defendant's motion in limine, docket 1208, part 4. The court orders that the state blur the video and that part is moot. The court denies exhibits 1 through 6. I don't know what video this is. It could be video from when law enforcement arrived and found the victim and they're blurring part of it and mooting part of it. That would, for blurring part of it, that would be most common. Or it could be videos where kids are shown and that is blurred. So we'll see. They're talking about 1208. Again, we don't know what the defense motions in limine 1208 are. We know that there are multiple parts. Let's see what the court says. The court, for reasons stated on the record, denies defendant's motion in limine docket 1208 part 6. The court denies 1208 part 5. So a lot of the defense motions in limine here are being denied. I don't know what they're seeking to admit or address because we don't know. The court addresses not docket 403, but addresses 403 and balancing motions in limine as they move on to 1208 Part 7. The court takes lunch. They are back on the record. The court, for reasons stated on the record, does what? What does the court do? I don't know. We don't know. It was sealed. Bloodworth requests clarification. We request clarification, but that part's just not there. Then they move on to address motions in limine, Part 10. The court rules as stated on the record regarding the defendant's motion. Ruled what? We don't know about 1208 Part 10, 1208 Part 11. The court denies Part 11. They then move on to 1208 Part 12. Mr. Bloodworth indicates the photo will be blurred along with sharing a new photo with the defense. So whatever photos they are talking about, the court's going to blur, or the prosecution's going to blur part of it. They move on to 13. The court addresses the parties regarding defendant's motion in limine, 1208 Part 13. Apparently there was a break. The court addresses considering immunity along with 804. We'll see whom the prosecution is considering immunity for when we get to trial. We don't know, but there is a consideration of immunity for someone. The defense addresses the court. The prosecution addresses the court. The defense asked to have until January 25th to respond to something, it seems. Then they talk about Dr. Kaplan, which we saw in the first day. The court talks to the parties talk to the court, the court encourages the parties to meet and confer. They talk about a review of the questionnaires for the jury. The court addresses the parties regarding the length of the trial in this matter. Can you tell us what they said? Can you tell us what they said? A lot of you are asking me what I think about the immunity. There are so many parts of this. We know that there has already been some kind of deal with CL. We don't know if there's been a deal with the person who sold drugs to CL. We don't know how much was told to the paramour and if he could be seen as aiding and abetting. There's too many people to know. We'll find out when we get to trial because it's going to be brought up. So it also might be multiple people because there are people involved in each part of this. So we'll see. The court addresses the parties regarding the length of the trial. We don't get to know that. Boo. Bloodworth talks to the court addresses the parties are to talk to each other about trial, Dr. Kaplan, and then the court will hear any additional motions on February 2nd. We don't know if that February 2nd hearing will be sealed or not. What's your guess? My guess is it's probably sealed. They had originally estimated 4 to 5 weeks, so I don't know if that has been modified. And then everything was sealed. And that is the end of the record. But the good news from today is that the court is allowing live streaming. I imagine the February 2nd hearing will probably be sealed because this one was entirely sealed, even though a lot of these motions were filed in public. And we went through briefly the ones that were filed in public. We have seen that. Let's try to summarize as best we can with how vague this was. In trying to summarize what happened in the sealed hearing of the Kouri Richins case on the motions in limine, some of the motions in limine that were addressed in court were filed publicly. So we had a chance to look at what the prosecution is asking for, but a lot of them weren't filed publicly. And we have very vague references of what the court was considering and denying or allowing in court. A lot of that was in the defense motions in limine. In the prosecution's motions in limine, we saw things like the walk the dog letter, and the prosecution asked for the first 3 pages of that letter. It seems that the court has said once the proper foundation, etc., is met, that that is going to be admitted. It seems, based on the very vague minute order rulings that we have, that the court will be allowing the walk the dog letter in, that we will be seeing numerous jail calls from Kouri Richins. We learned some new information about what's in those jail calls, including the fact that on recorded jail call, Kouri Richins is talking about a meeting she had with a defense attorney in 2021. We know that Eric Richins changed his will and the trust and how his estate was to be handled in 2020, November of 2020. So we have Eric Richins changing things in November of 2020. We have Kouri Richins having a meeting at some time in 2021 with a divorce attorney, which is going to allow the state to make some more arguments about what Kouri Richins knew about what was in the prenuptial agreement. And then we have the February 14th, 2022 attempted murder charge for Kouri attempting to poison Eric Richins, as the prosecution alleges. And then we have the February 3rd overnight to the 4th homicide that's charged in this case for Eric Richins. So we are looking at from late 2020 to very early 2022, quite a lot happening. I'm very interested to see what else is in those jail calls. But the jury, it seems, is going to hear that walk the dog letter where Kouri is lining out the connection that her attorney Sky wanted to make between Eric Richins procuring drugs and fentanyl from Mexico. We also took a quick side quest to look at an article from people.com because there were motions in limine regarding the children's book that Kouri Richins apparently had ghostwritten, and the cover of the children's book that shows Eric Richins with a halo and angel wings on it coming out of the clouds. And in that article, People states, and I imagine that they would have spoken to people that knew Kouri and Eric, but states that Eric Richins went on his mission through the Mormon Church to Mexico City. I didn't know that there was more of a connection between Eric Richins and Mexico, aside from what we had seen in the walk the dog letter. I don't know if the jury will know that. They might not, but it does close some loops for us understanding why that might have been such a, hey, we need to connect these things to Mexico, because Eric has a connection to having lived in Mexico City for 2 years. And maybe that's why Kouri was so focused on it in the walk the dog letter / novel. Also, I think if Kouri Richins comes up and tries to testify that that's all fictional, it's a novel, will we see the prosecution be like, girl, you didn't even write the children's book. You didn't even write the children's book. What are you talking about? I don't know. Maybe we will, maybe we won't. So we also learned that there are more text messages from in custody that the prosecution wants to bring in, that the prosecution is asking to redact certain portions of conversations and then admit quite a lot of defendants' recorded jail calls and text messages, of course, in addition to all the other digital evidence that we have seen. So in looking at the court's rulings, we know that the walk the dog letter, once it's, shown that Kouri Richins, I think, has authored it, is going to come in. And then the court also made ruling about an orange notebook. And we heard reference to the orange notebook during the motions to suppress, where the defense was arguing that that was improperly seized. It seemed at that time that the prosecution was going to be arguing inevitable discovery. And then we are at the point now where they're arguing what part of that orange notebook comes in. The prosecution said that it was journaling about the March 3rd, March 4th time period of the passing of Eric Richins, and that the defendant lays out in her journal what happened from her perspective in that time frame, in the first pages of that orange journal. So Kouri Richins, according to the prosecution, was journaling about the death of Eric Richins, and they have sought to admit that. And it seems that the court's ruling is that that is going to come in. Again, if the proper foundation is laid for it, that journal is in fact in Kouri Richins' handwriting, that she is the one that wrote it, etc. So the prosecution is going to have a lot of Kouri Richins' own statements, writings, recorded calls, and more coming in. So when this goes to trial on February 23rd, we also saw a docketed item today that Court TV has been granted pool camera access and the court is allowing live streaming. So will we be streaming gavel to gavel from Utah again? Yes, we will. There are going to be a few hearings before jury selection gets underway on February 11th. I don't know if those are all going to be sealed or not, but at this point, it seems that the court would rather lock everything down until the jury is seated. So I imagine we might not hear any more in court or see any more coverage in court other than the filings that are going to be busy between the end of January and the beginning of February when jury selection begins. So it looks like we will be streaming gavel to gavel for the Kouri Richins trial starting at the end of February. Of course, there are other things we will be covering before then. But what we need to do now is go to your questions and answer some of those before Emily just absolutely falls over. So let's get to some of your questions, shall we? Questions? Yes, yes. I pushed the thing and it didn't thing. And then it thinged very late. What? Rude thinging. Emily, your mic's unmuted. No, I know it is. No, I'm aware. It thinged very late. I was like, that's a weird delay, but I know the internet is being very strange today, so I'm not surprised that the internet is being very strange today. All things. Hey, at least we're still here. At least we're still here, right? We're still online. Despite all the tech of whatever's happening today, we're still here. Heather said, not yoga with Adrian catching strays. No strays meant. It was meant as I mean, isn't this what we're doing in our morning routines when we're living in our ideal world? Isn't that what we're doing? It was meant as an homage because I think yoga with Adrian is fantastic. And so, when I'm imagining Kouri like setting up her girl boss morning and journaling about the death of her husband while planning to, write a children's book about it while also Googling when do you get life insurance and luxury prisons. I just imagine that she's probably like, I'm going to be that girl. This is my that girl morning routine. Like in my brain, I picture like influencer Kouri being like, follow me. So it was meant as an homage of like, if you're going to do a morning routine with some yoga, that's where you're going to do the yoga. Strays were not intended. Hopefully not. Cause that's not how I intended it, but yes, I love yoga with Adrian. Let's see. Some of you are saying the Wade Wilson calls are wild. I haven't looked at those. Wondering if I should take a free day here or there to go to Fairfax and watch the Banfield case. It's an hour drive away. I mean, it doesn't seem that the courtroom's super full and you would get to see Judge A in real time. If you've never sat in on a trial in real time, it's illuminating. Some of the days can be slow, but it is going to testify. That would be an interesting thing to see. Closing arguments are always a great day to be in court, and you generally know when those are happening. But watching how court operates in real time is fantastic. I love seeing court through the lens. Why? First of all, I am old. Sitting in court on the hardest benches ever, A, give me PTSD to a very Catholic upbringing. And B, I mean, at least in court, they don't make you kneel. But also, the seats are so uncomfortable. They have no back support. You're like, bring a cushion, bring a back pillow for your lower back. They're very hard seats. And B, remember, when you are in court, you will see the back of everyone's head except for like the witness and the judge. So it's also hard to see what the lawyers are doing or saying because you're only getting the back of their heads. What I love about the way that Court TV and others set up their camera is that they generally have a camera like behind where the witness is, so you can see the lawyers, see the defendant, see the parties at the table, and also see the witnesses. And I think that's fantastic. I love it. So if you have the opportunity to go to court and a case that you're interested in, go and experience what it's like in real time. Always go, for sure. Some of you are asking about the internet outages. So far, so good. I'm glad we're still here, but YouTube has been a little up and down today. So we'll see. But yeah, if you can, go. Annie said part of my job in the prison was listening to calls. This is a job I would sign up for. Just like I've said, if there's ever like a housewives unit at the U.S. Attorney's Office, I'm like, I'll consult with you under NDA. Like, tap me in. I want to know, because you learn all the things. And also, yes, the prisons also monitor calls to make sure people aren't planning like all kinds of harm. I'm going to leave it there. Emily, don't help people crime better. Let's see. Casey Cat said, I find it interesting that these criminals still don't understand their phones, their computers, ring cams, their cars, etc. We'll tell them, look, here's what I've got. If you are like, let's liken it to something non-criminal, Survivor or like Amazing Race or what have you. Our brains fundamentally operate different when we are under different kinds of stress. It's why when I am sitting at home watching Survivor and they're showing like whatever puzzle from ahead and you're like, move it to the left, move it to the left. And it's so easy for me sitting on my couch to be like, how are you not completing this puzzle or this game or whatever? But when you are in the moment and under that kind of stress, and then also under the other stressors of the environment, the lack of sleep, the lack of food, the lack of like clothing and showers and comfortable toilets or whatever, your brain can't always make decisions well. When you are in fight or flight, your brain does not always make decisions well. And without getting into not my field of expertise and talking about how our systems shut down decision-making and good decision-making, depending on the other stressors that are going on, it is surprising that people do not understand that your phones and everything will tell on you and make plans for that. However, I would imagine also the stress for most of a decision about, in Kouri Richins' case, am I going to procure narcotics and give them to my husband, and then am I going to go to prison forever for it? That sometimes things will slip through the cracks because you're not operating at a 10 out of 10. Now, the people who can crime and operate at a 10 out of 10 probably aren't going to be in court that we're going to see. Is just the sad reality of the fact. But most people do not execute plans well under that kind of stress, if that helps. So yes, it surprises me, but also brains. Imagine what Proctor's brain did when he was like, oh no, my entire iCloud is wiped. And then he was like, no, it's not. A lot of the cases that we see are not people who fall into the categories of like a serial killer where their brains are operating differently. And you can see how long it takes to catch some of them. Their brains are fundamentally processing things differently. When you are looking at humans who are making a very wild choice that most do not make, their ability to account for what they think they can account for is inhibited. And I think we saw that with Walsh most recently. He tried to be as careful as he could. It seemed that Walsh had a plan and was trying to be as careful as he could. And even then, he couldn't account for everything. So, Matt, it's good to see you in the chat. Matt, future ESQ, said, hey, EDB, this semester is wild already. FinAid sucks. I'm so sorry. Financial aid is much to navigate. Good to see you in the chat. Thank you, Lacey, for the 5 gifted memberships. Thank you, Angel, for the 10 gifted memberships. Hope all is well. And to everyone else who gifted membership, lots of you did today. Alley-oop, thank you for the gifted memberships. Lasagna Wolf, no. Yes. Something, yes. I think there was a different username before this, but then all the usernames chatted, which is wild. Thank you for the 5 gifted memberships. Let's see. I'm going to answer some other answers as best I can. Let's see. The Kates are excited for more Judge Audiobook. Kate, History Mysteries. All of us are excited for more Judge Audiobook. Emily, timey-wimey. Yes, time. Did Ron ever get what was coming? There's still not a ruling in that case. I'm covering it when we get it, but I don't know yet. Catherine said, are you following the Banfield case in Fairfax, Virginia? I am keeping an eye on it and trying to figure out how we'll cover it here together because I can't do gavel to gavel. I talked about that a little bit more at the beginning. So I covered it a bit more at the beginning. Bearded Lady Dog Mom said, EDB, I'm navigating a new scary world of chronic pain. I'm sorry. Stuck at home a lot while I adjust. Thank you for being such a warm, engaging space to just be. You are in good company with the law nerds. This is a community that has navigated just about everything you can imagine that humans have to navigate. Chronic pain changes your lives in ways that most can't fathom. And it's hard when people can't see because they don't know that you're just in pain. And it also changes how you navigate the world. And it's hard. When I was home recovering from my second spinal surgery, it was more acute because it had been such a journey to get to the second spinal surgery, but you can feel incredibly isolated. And I think this community helps feel less isolated, even when you are physically isolated, for all of the different circumstances that may be. It is a hard thing to navigate, but you are welcome. And do not ever apologize. A lot of you are like, I'm sorry I couldn't chat recently. It's okay. You know you're here. I know you're here. You know what you can engage in and when you can. I often see comments in the chat like, sorry, I'm late. No, it's okay. Get here when you get here. There's always replay. No need to apologize. Be here when it works for you. My goal is that you have choice. You never need to apologize to me. We're here and we're going to be here. And some days, my days are going to get shifted around depending on things that I've got going on, like being sick, which is where my brain is today. Very slow. It is very, very obvious, I think. Reese said, EDB, thanks for turning me on to Traders. Love it. Look, new season of Traders, episodes 1 through 3. We have talked about it over in the Law Nerd Lounge. I am not going to spoil it. Thank you, chat, for not spoiling it, because not everybody can get to it. But I was surprised. There are some new aspects of the game. I don't know how I feel just yet. I don't know. We'll see. There were some surprises that I was surprised by. Okay. We'll see. Charlene Anderson said, headed to the 5-year milestone. It's so fun. We've got the new little badges. It's great. So Traders is a lot of fun. I know a lot of you have also talked about watching now Bon Appetit, Your Majesty, which is a lot of fun. If you are not watching Trials, it is okay. And sometimes it's really hard to focus when you aren't feeling well. So don't feel bad if you go back and rewatch things. Don't judge you. We're not. You don't. All right. Jen, it's good to see you in the chat. Ice Baby said, we are built for survival. When emotion goes up, logic goes down, meaning rational thinking starts to shut down when our body starts to go into survival mode. Biology is fascinating, right? Brains are fascinating. And so, you look at a case like we'll talk about the, is it Benefield? We'll talk about they're calling it the au pair case for just a moment. But talking about the au pair case, I want to figure out how to cover that, even if we're not doing it gavel to gavel, without setting up the expectation that we're doing it gavel to gavel, because I just can't, with all the other things we have going on, but trying to condense some key aspects of the case and key witnesses, because I think a lot of you are just like, no, but I want to watch it with you. I want to watch it with you too. But when we went through opening statements, I didn't know much about the case. I had seen it when it happened, and I was like, oh, a husband's alleged to have had an affair with a nanny and then killed his wife. Okay. That's not great, but I guess we'll see how it goes. And then I didn't follow it much more. This Kelly B, this is the case that Judge A is presiding on. They're calling it the au pair murder case or whatever. It's not Norfolk. Damn it. Fairfax. That's Judge A's case. Fairfax versus Banfield. But when they got to opening statements, there's a lot more there. When when they got to opening statements, there was a lot more of a plan that went into that. So we might have to watch opening statements together because there was a lot more planning that went into that. And there are 2 homicides here. It was not just the wife who was killed. There was somebody else in the house that was killed. And the husband, it seems, went into a full setup that was pulling somebody else in to try to create a scenario that would allow the husband to kill everybody. It's going to be interesting to see how the prosecution pieces it all together. So I know that the au pair took a deal. That doesn't surprise me. The au pair was living with them from Brazil. I think when she moved to the States to live with them was like 22 years old. And we will see. I'm going to take a look at doing key witnesses and opening statements and go from there, but I'm not going to be able to do gavel to gavel. As long as you guys understand, we're not going to be able to do gavel to gavel, and we're going to do some key witnesses. I will do that in a way that we can. I'm just going to have to look at how to narrow that down. But if I cover a witness, it's my intention to cover the entire witness, but not every witness that testifies. So I'm going to keep an eye on that and see how we're going to do it, because they say it's going to be like a 4-week case. I don't know if we're going to be able to. I can't do a 4-week case right now because it's going to roll into some other hearings, but we'll see what we can do. No, we're going to get no, or really, Wolf Kara said, unless we get invested, or really no, or really no, or really no, because we're going to have, with Cardi B, there weren't that many witnesses that we could cut out because it was such a short trial. But with this one, it is going to have to be some witnesses we just don't cover at all. And I summarize, because with 4 weeks, we're not going to go through every witness. Like yesterday, I think they did a lot of body cam. We're not going to go through like all the body cam witnesses and stuff. There will be some, but we'll see. I got to see how we, I've got to start feeling better because I'm real annoyed that seem to be getting sick again. So I will let you know about tomorrow. And I don't know if I'll be streaming tomorrow. It might be your girl needs a day, but we'll see what we can do tomorrow. And I'll let you know. So I'll keep you posted on tomorrow. I'm not sure about tomorrow. And then we do need to do some members only this month. I need to sit down with my calendar. I've been saying that all week. Sina, I have pulled that lawsuit, and I don't know if we're going to put it on a podcast or if we're going to do it on a members only live, but I have pulled the Haley Bailey defamation lawsuit. Because it's an interesting one. If anybody doesn't know about the Haley Bailey, does she create on YouTube too? I know she's a TikTok creator, like a short form creator. I don't know much more than that, other than I see her as a short form creator, but she's being sued by her ex-husband for making comments about his penis. And, so he's suing her for defamation because she talked about his penis size and talking about it being uncomfortably large. And so there's a defamation lawsuit about that we just haven't had a chance to cover yet. So he says it has subjected him to unwanted ridicule, and we will see what happens, because it's proving defamation in that context is going to be interesting. It is kind of a wild lawsuit, and I think it's going to ask the question of where are the boundaries of privacy versus opinion versus, I think it's going to touch on whether defamation is really the proper vehicle for a lawsuit like this, or if it's more like invasion of privacy, because I can see with invasion of privacy, because there are certain things you might not want from your life to become private or to become public. And I don't know if this is going to be a truth as a defense, because that's going to get awkward, or if it's going to be a
That's my opinion!
I don't know. It's just going to be an interesting one, because to me it seems at its face more like an invasion of privacy than maybe a defamation. I don't know. It's an interesting one. And it is on my docket, because it's going to be interesting to navigate opinion, defamation, invasion of privacy, boundaries of privacy, and where the boundaries are of what is shared from a personal life experience versus what is not shared. But the lawsuit, I think, is going to bring all of this to the forefront of conversation even more. And I don't know if there's loss of income based on the defamation. So yes, it's on my docket. Yes, we have another lawsuit that involves 50 Cent, and we might just need to do a demonetized day of covering both of those lawsuits together, because I think it's going to be a tough one to argue that it's not opinion and then truth as a defense. Like, how do you do that with the court? Like, how do you truth as a defense that with the court? How? So also, I think opinion is going to be the direction. Yeah, so I'm not sure how that case is going to proceed in court. But it's not a murder case, so we'll definitely be talking about opinion and privacy and defamation. So what you say in public can come back to bite you. I imagine this is going to be a lawsuit that will resolve out of court. I'm not sure why you would file it, and I don't know how that's going to go. But we'll see. We'll see. Clearly he's upset about it. I can imagine situations where you are in a relationship with someone and they start talking about intimate details and your body, where that could be incredibly uncomfortable. I don't know if the court system can undo that. I understand the violation of privacy. I just don't know if the lawsuit helps or if it just shines more of a spotlight on it. So I also don't know if there's injury there? Like, what are the damages? Like the monetary damages? So I don't know how that's gonna work. And I also, I don't know how that's gonna go with the defamation case. So I feel like all of us should just be like, okay, we can just see, not for ourselves. We can't see for ourselves. Don't Google that. We can just put that on the docket and see where this defamation suit is going to go. Because it's, I put it on the docket and was like, what? So maybe we just have a WTF stream of some of the strange lawsuits that have come across. I mean, if they'll all fit on one docket, I suppose they might be too big for one docket, but maybe we'll just embrace a demonetized day, because there's another lawsuit that we briefly touched on that we could circle back to and just let, it's not food court, but we'll just have to see what we do with we have a couple of lawsuits about that we might need to circle back on. So it might be a kind of a full-throated day of coverage, and maybe we don't cover every single sentence of the lawsuits, but as long as we get the general thrust of those lawsuits, I think we'll be well covered. So, chat, I grant your motion for a unhinged day of docket because, well, I think it's needed. And if we're not going to do food court, it's fair to maybe do a demonetized day of trials. So we will gently massage our way around some of the more difficult facts as best we can, and just make sure we stay hydrated. So we'll just do like an after dark, not after dark. And we'll see how much we can take of those cases, chat. We'll see what we can do. We'll see. So we've got some trials coming up. We've got some trials that are happening, and hopefully for those of you that spit out your drinks, you have not damaged any of your electronics. And we'll just, it might be a NSFW type of a work stream, but we're going to have to just wait and see. But it's on the docket. So thank you for asking. It is on the docket. I did immediately go, docket. We'll see when we get to it, but it's on the docket. We can't leave it on a shelf for too long. It's going to be an earmuffs day. We'll just do all that together. It'll be great. And chat, for those of you who don't have the Lawnerd app, make sure you grab the Lawnerd app. I will keep you posted about tomorrow. If I am feeling worse than today, it's going to be difficult for my brain to actually stay on a linear path and give you helpful court coverage. So I will keep you posted tomorrow in the Lawnerd app about tomorrow. And if I am feeling worse than today, I will probably rest, and then we will get back to coverage and a podcast and the rest of it. So Lawnerds, I'm going to go take some zinc and see if we can get feeling better before tomorrow. I appreciate all of you. Thank you for being here. I am so excited that Kouri Richins is going to be streaming. I'm going to try to make sure that we can squeeze in all the other cases that we want to talk about before that trial starts. Because once that trial starts, we're just going to be like in trial for a couple weeks, and I'm looking forward to it. So, Thank you, Law Nerds. Thank you for riding with me. Thank you for being here. And I will see you soon. Make sure you have, for those of you that are new here, get the Law Nerd app. It's free on iOS and Android. I mean, it's not going to do a lot of good if all the cell records are down, but at least we were able to stream today despite all of the tech happening in the world. Yay for us. Law Nerds, take care of yourselves. I will see you soon. All right, let's roll the outro. Take care. Bye, guys.
Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.